Is Minority Counsel Mr. Lowell to question the witness for 30 minutes.
Thank you, Mr. Chairman. Good afternoon, Mr. Starr.
Good afternoon, Mr. Lowell.
Chairman Hyde has again this morning announced his desire to conclude the inquiry by the end of this year. With that in mind, it appears that you may be the principal witness that the committee hears, and that yours will most certainly be the primary evidence considered. Given this, Mr. Starr, isn't it true that on September the 25th, 1998, without any request by this committee to do so, you sent the committee a letter which agreed that once questions about your conduct were raised, those questions were not incidental or tangential, but they were, quote, appearing to bear on the substantiality and credibility of the information you provided to the House in our referral?
Well, Mr. Lowell, the letter, and I believe I'm recalling the one that you are speaking to, we've had a lot of correspondence back and forth, as you know, but the letter, if my recollection serves me, goes to the circumstances with respect to the events of the evening of January 16th. And there were certain allegations being made about the circumstances by which we approached Ms. Lewinsky, what was said, and the like. And that's what we were talking about, or what we were addressing in that letter, if it again is the letter you're indicating. But may I take, I must say, gentle issue with the idea that this is not the information that is before you. This is the information. And the supplemental materials and the appendices reflect the hard work of the grand jury who has evaluated the witnesses. I am the independent counsel. My colleagues and I have gathered the information. But no, witness not in the sense of a fact witness, except to the extent, obviously, that members want to inquire into the activities of our office, and I'm obviously going to try to be responsive.
If you look at tab 1, Mr. Starr, of the exhibit book in front of you, just so that we're clear, indeed, it is the September 25th letter in which you write to the committee and state that the conduct, in this case, of how you dealt with Ms. Lewinsky goes to the substantiality and the credibility of the evidence you sent. That's the letter, is it not?
Yes, it is.
With that in mind, Mr. Starr, the members of the committee and I have a series of questions that, as you indicated, will elucidate the substantiality and the credibility of the evidence. To begin with, in your testimony, and if you look at your testimony, it would be on pages 31 and 50, okay, you acknowledged that you had a number of choices to make with respect to sending a referral to Congress. To quote from your morning's testimony, you stated that one of the questions you needed to decide was, quote, what to do with the evidence. And then you said we needed to decide, quote, how do you write a referral? You recall your statements with those choices, correct?
Yes.
With respect to the choices you made, Mr. Starr, you would have to agree, I take it, that there are substantial differences between the referral that you sent to Congress on September 9th, 1998, and the one that was sent by Watergate Special Prosecutor Leon Jaworski, to whom you referred in 1974. You would not, would you?
I'm not sure I understood.
You would agree that the
formulation
methodology,
yes,
the procedures, and the decisions that you made differed substantially to the ones that he made 24 years ago?
Well, I understood the question. The answer is yes, in that our referral, your question had a number of elements, and so I want to be precise. Our referral did indeed differ, and if I may explain why. Mr. Cox and then his successor, Mr. Jaworski, were dealing not in an environment controlled by a law. And the assurance I want to give this committee is that we studied the law, namely 595C, very carefully. Mr. Cox, Mr. Jaworski never had occasion to look at 595C because it did not exist. And so we examined that law, we examined the background, and we went through the process that I described this morning. And we determined, for example, that with respect to some of the matters that in my effort to provide assistance to the committee, some of the events with respect to the Whitewater investigation, we were not satisfied in December of '97 that that information that we had at that time standing alone met the threshold. That has been what has governed us. And indeed, if I could just add this, the statute was framed in terms of grounds that may constitute grounds for an impeachment. The very language that Congress used suggests to me a process of judgment. And we came to a judgment as opposed to the situation that obtained absent the statute with respect to Mr. Jaworski in 1974.
On that point, Mr. Starr, as I understand it, and I think you, in referring to the differences, this is how Mr. Jaworski's report has been characterized by federal judge John Sirica, who reviewed it in order to send it to Congress. Judge Sirica wrote that Mr. Jaworski's report draws no accusatory conclusions. It contains no recommendations, advice, or statements that infringe on the prerogatives of the other branches of government, that it renders no moral or social judgments. It is a simple and straightforward compilation of information, and it contains no objectionable features. This is how your report has been described. It is a report that marshals and characterizes the information into an aggressive piece of legal advocacy. It is one where there are few of the factual assertions are left to speak for themselves. In short, it is a document with an attitude. It is notable for its failure to acknowledge that there might be more than one way to view at least some of the evidence. And that was from the Supreme Court reporter of the New York Times, Linda Greenhouse, on September the 12th, 1998. It cannot be your testimony, is it, Mr. Starr, that the 595C background material that you say to this committee, which was involved in reviewing that statute that you reviewed, required you to make the accusations, conclusions, in short, have a referral with an attitude. Is it?
My opinion of the statute, or my reading and interpretation of the statute, Mr. Lowell, is that I am called upon to establish the reason that, in the independent counsel's view, the matters that I send before you may constitute a grounds for impeachment. That's a very serious and weighty matter, and we approached it in a very serious and weighty manner. I have the highest regard for the late John Sirica. I served with Judge Sirica, but he was addressing, in all fairness, a totally different set of circumstances, because it may be that we have different interpretations of the statute, but with respect to any particular, reporter's evaluation or description, I stand behind this referral, and I'm sure there'll be questions about it. What we tried to do in this referral was to assemble in an organized form, rather than sending you simply truckloads of unorganized information, give it coherence, and then it is your judgment. And thus, if it is the judgment that this referral has not, in fact, stood the test of your close examination, did we get the facts wrong? Then, of course, you should come to your own judgment and your own assessment. But this reflects, just so the committee knows, the views of some of the most experienced prosecutors in the country. I stand behind it because it is mine. I stand behind each word of it. It is my ultimate judgment. But this is a professional product. It's not the product of one single person.
Whether it be your judgment, Mr. Starr, or the judgment of your entire staff, one thing I think you will agree with is that it was your and your staff's decisions to include the words premeditated, concocted false alibis, deceived, pattern of obstruction, lying under oath, perjury, which words you will never find in the report of Leon Jaworski when he was reporting the same kind of evidence to the Congress 24 years ago. Aren't I right about that?
I don't think that I've not reviewed all the material that Mr. Jaworski delivered, and I'm not taking issue with the fact that this document is no doubt in many respects, different than the very kind of environment and legal standard under which Mr. Jaworski was operating. But Mr. Lowell, if I'm going to, speaking through my voice, but if our office is going to inform the House of Representatives that there may be substantial grounds for an impeachment that is so weighty, that is so serious, that you need to have the benefit of our judgment and our assessment of the facts, informed by our watching the witnesses, listening to the grand jury and the way the grand jury reacted to witnesses, the assessment of the grand jury, and then to give you our judgment. But obviously this body is entirely at liberty to reject this referral as not being substantial or credible. It is entirely your judgment. And one of the points I did try to make in the opening statement is, I believe, and you may disagree, that I was called upon to give you my judgment and my assessment, and I have done that. But it is the responsibility of the House of Representatives to use this to the extent that it wants, to discard it, to do whatever it thinks is necessary to come to its judgment as to whether there should be any proceeding, some sort of proceeding or not. This is a tool. This is only a tool for you to use as you see fit. But I don't think that it's fair to criticize my office for not following a pattern that was not governed by a statute. And Colonel Jaworski is not here to tell us what he would think if he went through the same process under the statutory regime that our professional colleagues went through.
Well, let me conclude this area because you invited it. I know Mr. Jaworski
I'm
is...
sorry?
You have raised something that I think...
I'm having a little bit of trouble hearing you.
I'm sorry. You have raised something that I think bears some note. When you were talking to about Mr. Jaworski not being here, but he did leave us his words. And these are the words that Mr. Jaworski left us. I think you must have known this when you were considering what to do with your referral. In talking about his decisions, the way you have talked about your decisions, in talking about how to send material to Congress about the grave and serious matter of presidential wrongdoing, Mr. Jaworski wrote as follows. And I want to know whether or not this was something...
Identify the document.
I'm sorry, you could find this on tab 4 of the exhibits in front of you, and I apologize, Mr. Barr.
Tab 4?
Tab 4.
Thank you, Mr. Lowell.
Mr. Jaworski, who left us his words, said, "The central key to the entire success was not accusing anyone. What we did is simply carried forward what the facts were, passed them on, not making an effort to interpret them, not making any sort of an effort to construe them, or to say what we thought it showed, and let it be completely non-accusative." So we don't have Mr. Jaworski, but we do have his words, correct?
Absolutely. And if I could, I'm sorry, may I just comment in light of your quotation? We did go through an evaluative process as I described. And while we did not have the benefit of Colonel Jaworski, except that which he has left us, I do think it's important for the committee to know that in light of the sober judgment, you're free to disagree with that judgment, but it's our professional judgment, that the President engaged in abuse of his authority with respect to executive privilege. We were guided by Sam Dash, who had very strong views on that, who expressed those views, and who felt that we had to use certain kinds of language that I think, Mr. Lowell, and I respect your views, you would disagree with.
I'd like to move to an area that will, I hope, reflect to the members some of the other choices that you had to make about the evidence. As I understand your testimony this morning, after the 4 years and however many dollars you've now spent, your testimony confirms apparently that your office is not and is not sending an impeachment referral to the Congress on what's been affectionately or not so affectionately called Travelgate, not what's been called Filegate. And on page 141, I think, of your testimony, you said that you have not...
At page
41 of your testimony.
Thank you.
You're not sending a referral on the original Whitewater land deal, and pointed out that in some of your investigation you've now learned that former Governor Tucker actually exonerated the president on some of the questions that you had.
Yes.
The referral you sent then, Mr. Starr, refers apparently only to the issues about the Paula Jones case and the questions of the president's conduct in dealing with that case. That's correct, is it not?
The referral itself does. We do, of course, if I may,
Please.
the referral does, in other respects, indicate the ties that we saw to earlier phases of our investigation and why we, in fact, were choosing to assess this. But you're quite right, both with respect to the two matters you indicated, as well as the specific testimony by Governor Tucker, that those matters will, in fact, not be coming to you.
Mr. Starr, part of the word, a key word in your title is independent counsel, correct? Independent.
Yes.
Part of being independent, I think you would agree with me, is being free of conflicts of interest that might bias your investigation, correct?
Yes.
And as I understand it, your testimony this morning indicated that on January the 15th, 1998, the Office of the Independent Counsel met with Deputy Attorney General Eric Holder to discuss your jurisdiction over the matter that has now been presented in the referral. Am I right about that?
I believe the date is correct, yes. Our contact with the department and those initial meetings was with the Deputy Attorney General.
In your testimony, Mr. Starr, you stated, and I quote, on page 30 of your testimony, that you, quote, fully informed the Deputy Attorney General about the matters under investigation. And I take it was because they had to make a decision about jurisdiction, correct?
Yes, we were there to discuss jurisdiction.
The independent counsel law, as you explained to the committee on pages 29 and 30 of your testimony, indicated that at the day that you were making your presentation, the Attorney General had a choice as to whether to recommend that you conduct the investigation or to give that responsibility to someone else. Isn't that also true?
Yes.
In that case, I suspect that you and your office would have provided the Deputy Attorney General and the Attorney General all the information that she and he would have needed to make that important choice. Am I also correct about that?
Well, certainly that which in our judgment was relevant to the decision, by all means.
Mr. Starr, though, isn't it then true that in fact neither the Deputy Attorney General nor the Attorney General had the facts that they needed, because not once in any presentation you or your office made to them about the material that you were now asking their jurisdiction over, that you did not ever mention the substantial contacts that you had already had in the Paula Jones case, the very subject about which you were seeking authority to investigate?
Mr. Lowell, let me address two aspects. You were asking about the jurisdiction, then let me come to the Paula Jones context that I had. We did not go to the department, Mr. Lowell, to say we must have jurisdiction. We took to the department an issue because we view the department as that entity of government to whom we look, to the Attorney General of the United States ultimately, to make jurisdictional decisions. And I was not in attendance at the meetings, but I can give you my impression or understanding, and I'll make this very brief. We made it very clear that there was, the information we had was that there was inchoate criminality, which is a fancy way of saying something is afoot. It's breaking now, it is fast moving, and we need to bring this to your attention, and then you make the determination. We think there is a jurisdictional justification for what we've done thus far, but we think there are serious jurisdictional issues. Now, it will be the Attorney General's decision. Now, what should the Attorney General have been informed?
Could I go over those with you? I mean, if you would turn to tab 5 of the book, I think you and I and the members of the committee will be able to go through the issues that we might either agree or disagree the Attorney General should have been informed about. Mr. Starr, on that page, you'll see that it appears that neither you nor any of the officials in your office told the Attorney General that before you became the independent counsel, your law firm, Kirkland & Ellis, was actually contacted to represent Paula Jones and eventually helped her attorneys to find the lawyer she chose. That was not mentioned to the Attorney General that day or at any other time that you were seeking jurisdiction or asking her about jurisdiction, was it?
Well, you're assuming that I had the benefit of all this information.
About whether your law firm had been asked.
Yes, in terms of all that, because I certainly had personal communications with Mr. Davis, but I would have to reconstruct what others may have done in other offices. It is a large law firm, so if I could just say what I, in fact, knew at the time that this activity was underway, the reaching out to the Attorney General when these events were first unfolding, was that I had, in fact, been contacted by, among others, Mr. Davis, with respect to an amicus brief or some participation on the constitutional immunity issue in 1994. And those had been publicly reported. It was all in the public domain. I indeed debated that very issue against Lloyd Cutler and Susan Block.
I'm sorry to interrupt you on that.
Yes.
The question that I asked, and I'm sorry to do it, was not whether you had contacts with Mr. Davis, which had been reported at some earlier point. I asked whether you had, or any of your office members, told the Attorney General that your law firm, that you were still a member of and getting a salary from, had indeed been sought out to be Paula Jones's lawyers. I understood you saying you may not have known that. My question is, you're telling me that Richard Porter, your partner, did not ever inform you that he had been asked to consider representing Paula Jones and had, in fact, assisted her in getting the attorney she ultimately chose. Is that what you're saying?
Well, my best recollection is no. I know Richard Porter. I've had communications with him from time to time. But in terms of a specific discussion with respect to what the law firm may be doing or may not be doing, I'm not recalling that specifically, no.
You do recall, though, that it was a matter that you admit that on at least 6 occasions you personally had conversations with Paula Jones attorneys over legal issues in the Paula Jones case.
I'm not sure. I had conversations with them just as I had conversations with others, including, and I think the record of these proceedings should reflect that. My position on if I could be permitted, my position on the constitutional immunity that the President enjoyed was very clear and was open. I was contacted, before I was appointed as independent counsel, by Bob Fisk. Bob Fisk was the independent counsel in Little Rock, Arkansas, and Mr. Fisk asked me whether I would be willing to consider writing an amicus brief on behalf of the Office of Independent Counsel, which, of course, he was appointed by the Attorney General. And we had conversations, or no final decision was made, but he engaged me in discussions with respect to that. We talked about the issues and so forth. So, Mr. Lowell, I want to make a point. It did not occur to me that issues with respect to constitutional immunity, it just did not occur to me, and fault me for my inability to issue spot. That's what we do in the law. We try to spot issues. But I never spotted the issue that my conversations with Bob Fisk, Gil Davis, my debating Lawrence Tribe on National Public Radio had the foggiest connection with issues that were unfolding at the time. And fault my judgment, if you will, but it just frankly did not occur to me, as I think happens to a lot of us in life, that you just don't view that as relevant information. And if I may say so, especially since my position had been so well known, and including the contacts with Ms. Jones' attorneys who reached out to me with respect to the constitutional immunity issue solely, exclusively. And the final thing I would say in response to your question...
I'm going to be cut off, Mr. Chairman.
Well,
time,
you said 6 conversations, and you made a very specific point, and I'm not trying to interrupt you, but you made a specific point, and I think it's only fair to say, I don't know whether there were 6 conversations. I know there were several, but they were only conversations, and it never ripened in, well, I'm talking about with Mr. Davis, and it never ripened into an arrangement, an agreement, to the best of my recollection, to do anything because of the circumstances that then occurred.
To use your phrase, did it not occur to you that you should tell the Attorney General, who was making a decision about whether you were an independent counsel, that your law firm, Kirkin & Ellis, in addition to ask to be Paula Jones' attorney, was providing legal advice, free legal advice, to a conservative women's group called the International Women's Forum, who are thinking about participating in the Paula Jones case itself? Did that not occur to you either?
Well, again, it's not whether it occurs or not. I did have discussions with and I think it's called the Independent Women's Forum, as to whether they would in fact file an amicus brief, again, strictly on the constitutional issue, not taking a position on the merits, but the president, through his very able lawyers, had raised a very important question. Does the president of the United States enjoy immunity? Everyone was talking about it, and no one was talking about it particularly quietly. It was a matter of vigorous debate. And the fact that I had these discussions had all been, to the best of my knowledge, part of the public domain. That is, they were reported. And by virtue of that, I do think it's unfair, I really do, to suggest that someone should, when circumstances are moving so quickly, go do a nexus search, making sure that everything is in the public domain and the like, especially under circumstances that were not only fast-moving, but it was very clear that what we were investigating were serious crimes of perjury that had nothing to do with the constitutional immunity of the president.
Mr. Starr, are you suggesting that when you told the Deputy Attorney General that he had to move with haste because this investigation was fast-moving, that you had no responsibility to also inform the Attorney General about these contacts that you and I are talking about, which might make the Attorney General, as you pointed out, have a choice to make between giving the investigation to you or giving it to somebody whose independence, bias, and involvement in the case was not questioned?
Well, I utterly disagree, with all respect, with your premise that to be involved on an issue of civil law and constitutional law in any way suggests a predisposition more generally. I would take the position that the President of the United States does not enjoy constitutional immunity from suit regardless of who the President is. It has nothing to do with the identity of the occupant of the office. It has everything to do with what the presidency is and the nature of our relationship to one another as individuals and whether we are all equal under the law. So it did not occur to, and one factual correction. You suggested in your conversations, I did not have conversations with the Deputy Attorney General. They were by others in my office who were reporting to the Deputy Attorney General on the information that was coming to us and then saying, what is your judgment? We're looking to you for guidance, and more than that, we're looking to you for a decision. And these issues did not, in fact, arise.
Did they, to your knowledge then, Mr. Starr, on that night where you were asking the Attorney General to make a decision whether you were the independent counsel she was looking for, tell them that while you were the independent counsel and still a member of your firm, your law firm, obtained a non-public affidavit in the Paula Jones case and then sent that affidavit on to the Chicago Tribune? And that, Mr. Starr, happened while you were the independent counsel and a member of your firm. Wasn't that something the Attorney General should have known?
I don't know. I'm not saying that she should not, but these are judgment calls that one makes, and it also assumes, shall I say, a computer-like ability to recall each and everything that has ever occurred or information that has come to you. And so, let me say this. The fact of my involvement with the Jones matter, my personal involvement as opposed to what issues one or more members of my firm may have been involved in, I think was known publicly and thus did not occur to me as something that was appropriate or was something that I focused on. Whether I should have focused on it, you may come to a different judgment.
Mr. Chairman, it appears to me that my questions, as short as I'm going to try to make them, might elicit answers that are a little longer than I expected, and I was hoping I'd get the committee's indulgence.
Well, I tell the gentleman that when your time is up, I'll grant you another 30 minutes.
Thank you, Mr. Chairman. It is about to happen, I thought. Mr. Starr, while we're on the subject of the Jones case, I think it is now from the material you sent to Congress pretty clear that your office did absolutely nothing to stop Linda Tripp from meeting with Paula Jones's attorneys to help them set up for the January 17th deposition of the president. And the fact is it not, that you had the power at that moment and the reason at that moment to forbid her from having those meetings, but your office chose not to do so. Isn't that right?
That is, I think, an unfair characterization. That is to say, it is once again assuming that there was information as to communications that she may or may not have been having. We did not, to the best of my knowledge, we did not have any information that she was in fact communicating with the Jones attorneys, and indeed, the record will show we began working almost instantly at cross purposes with the Jones attorneys in order to protect this investigation. And we thereafter told Ms. Tripp, when it became obvious that she was talking to someone in New York, who apparently in turn was talking to someone in Newsweek, that she did have to protect the confidentiality of these matters that were ongoing.
I'd like to get to the date, though, and see if you and I can agree that there was a moment that you had not only the motive, but you also had the ability to stop her from doing what we've now learned that she has done. You went to see the Deputy Attorney General on January 15th. Prior to that, on occasion or two, your officials in your office had met with her. And when you went to see the Deputy Attorney General, it's true, is it not, that one of the things that you told him, or your office told him, was that this was likely to start getting leaked, that there was a reporter that was on to this investigation and he needed to move quickly. Isn't that a fact?
Yes, we made it's my understanding that we made the Deputy Attorney General aware that there was a reporter from Newsweek. We had not known about that initially when the information first came to us, but it became very quickly apparent that there was, in fact, a Newsweek reporter who was on the story unbeknownst to us. And so, yes, we said to the Deputy Attorney General, this is another factor, this is another consideration, and I believe, I don't know, but that I believe that that was brought to the Attorney General's decision.
So you knew that there was press people that are on to the investigation, and at the same time you also knew that Linda Tripp had illegally obtained information that she needed some form of immunity for, and in fact in your meeting with her, your officials said to her, we will give you immunity for giving us that illegally obtained information. That happened too before you met the Attorney General, right?
Well, with respect to federal offenses, we were aware that there might be an issue under Maryland law, but obviously could not confer immunity that she might have with respect to state law. And what we did know is that this was a witness who told us a very important fact. She said, I was a witness in the the White House Travel Office investigation, and I have additional information that I did not give you. And she was being asked, Mr. Lowell, to commit perjury. And so we moved very quickly, and there was a very important reason for moving very quickly to bring it to the Attorney General's attention through the deputy, and that is a witness who was involved in one of our ongoing investigations was being asked to perjure herself and otherwise participate in unlawful activity.
So if I can put if I could put these steps together. Linda Tripp came to your office with information. That's a correct fact. You were worried that there was somebody talking to the press that required the Attorney General to act quickly. That's a fact. You knew that Linda Tripp had obtained information, including the very tapes that provided the evidence that you sought to get permission to investigate from the Attorney General. And you didn't put those three things together to say to her, and by the way, we're worried about the press. You were worried enough about it to ask the Deputy Attorney General to move quick. You're saying you didn't tell Linda Tripp not to be talking about that stuff to anybody?
No, I think that's an unfair characterization. We did, in fact, promptly tell her, and events were moving very quickly. Within a short time, when it became evident to us, because things are not immediately evident when matters are first developing, and so you have to assess the facts. And so when it did, we instructed her, it's my understanding, that my colleagues who were dealing with her, who were experienced career prosecutors, made it very clear, stop communicating with someone who we felt was in fact, or at least potentially was, a source for Newsweek. And indeed, it is my understanding that the witness in question proceeded to change her phone so that she could, in fact, carry out our desire, our instruction, which was, and we had no interest, Mr. Lowell, we had no interest in this matter being made public. We had no interest whatsoever in doing anything other than our duties as honorable prosecutors to bring information to the Attorney General, let her assess it, and let her make her judgment as to should it be investigated, and if so, by whom. Now, you can say you should have told her X, Y, and Z, and I would say that's Monday morning quarterbacking.
Well, it's not exactly Monday morning quarterbacking, Mr. Starr. If you'll turn to tab 16, you'll see the agreement that you actually engaged Ms. Lewinsky herself in when you decided to give her immunity, as your officials had already indicated to Linda Tripp on January 12th that she would be getting immunity for her taping. And you'll notice in tab 16 that it wasn't Monday morning quarterbacking for you and your officials to give Monica Lewinsky not only immunity, but to make a condition of her immunity that she not talk to witnesses, that she not disclose information, and in fact, that she not do the things that you now know Linda Tripp did. Why didn't you put the same restriction on Linda Tripp?
What you see is the result of a very careful discussion, negotiation with very able lawyers. This was not done. The immunity agreement that you have before you was not prepared under exigent circumstances with things moving so quickly. We did have to move quickly in our judgment with the information that came to us from Ms. Tripp. And so one handles different situations in a variety of ways. But I relied on my professional prosecutors to come to a judgment about what should in fact be done and how it should be done. And to, in fact, when it became, as I say, evident that there was an issue, I think they brought it promptly to the Deputy Attorney General's attention and also sought to take what they viewed at the time. These are judgment calls.
You're not suggesting to the committee that while it might have taken a lot of time to negotiate the actual clauses of an immunity agreement with Ms. Tripp, that on the day that she said she was in trouble and asked for immunity, your people could have not said to her, well, if these tapes are illegal, don't give them to anybody, don't talk to anybody about them, keep them to yourself. You didn't need an immunity agreement to tell her that.
Well, I think that's right, because one of the things, and I should clarify that what we entered into with Ms. Lewinsky, and I think this does need to be clear, was a transactional immunity agreement. She was going to enjoy immunity from prosecution. What we were giving Ms. Tripp at the time was something that was much more limited, an act of production kind of immunity. Give us material, at least that is my understanding, that we were at that point in our discussions with her, simply saying, give us the information, because she had come to us with very serious allegations. And when we didn't ask her to come in, she came in, she comes in, she provides this very serious information that raised very potentially serious offenses, and we wanted, in fact, to gather information as quickly as we could that would either corroborate or disprove the truth of that. So the decision that was being made initially was what we call
But you are not
active production immunity.
I'm understanding you, but I'm also understanding you say that you're not contesting that on that day she came in, she had the conversation, she showed you the tapes or told you about the tapes.
Yes, she did
You
not.
had both the authority to give her immunity and the authority to tell her not to talk. You did the first. You didn't do the second, did you?
Well, I would have to double check to see exactly what we did tell her. But no, what I am trying to make as clear as I possibly can is that what we were saying to Ms. Tripp, you have given us this remarkable information, allegations. They are extraordinarily explosive that perhaps go to the President of the United States. We need backup. And she was coming to us as a witness, and this information was not, at the time that it was first coming to us, in the public domain. So we took the steps that we thought, or my colleagues who were making these decisions on the spot, took the steps that we did. But if the suggestion is we wanted her to go public, the suggestion is absolutely wrong.
I think you misunderstand my question. I could well understand why people in Linda Tripp's position and your staff working with her didn't want the investigation to become public. but I could also understand why Linda Tripp wanted the information she had to go into the Paula Jones camp, and I could understand that you had the authority to stop that, but didn't do it.
But what we did do, Mr. Lowell, in fairness, and this isn't the glass is half full versus half empty, what we did, once it became clear that there was a following by the Jones lawyers of our investigation and the subpoenaing of witnesses in our investigation, we took prompt remedial action. We went to Judge Susan Weber Wright and we said, stop it. Please have them stop it. And that is extraordinarily important because that's what we took deliberatively as opposed to under the exigencies of the time.
On the exigencies of the time, one last question.
Yes.
You're not suggesting that you and your staff that were talking to Linda Tripp and then going to see the Deputy Attorney General were not aware that on that following Saturday, January the 17th, the President of the United States was already noticed for his deposition. You're not telling us that, are you?
No, we did know that, and indeed the Deputy Attorney General and then the Attorney General of the United States, Mr. Lowell, knew that there were serious allegations. This was several days before the deposition. The deposition was on Saturday the 17th. The Attorney General made her decision knowing the information that we had, and we were transparent. We shared the information, Mr. Lowell, that we had fully with the Justice Department. Our concern...
Sorry, the information you had about what Linda Tripp gave you, not the information that you had about the Kirkland and Ellis involvement.
Yes, I'm sorry. The information that had come to us with respect to the investigation, we shared fully with senior career prosecutors at the Justice Department operating under the direction of the Deputy Attorney General, and she then, the Attorney General, made her decision that the matter should in fact be investigated. So that was the first judgment. And secondly, that the Department of Justice did not want to do it.
Let me turn our attention to some of the other aspects of gathering evidence, because I know many people will have additional questions. I know you don't disagree that independent counsels, although not in the Department of Justice, are required under the rules and under the law to follow the law that applies to federal justice department officials, prosecutors, and investigators. I know you've said as much in your speeches that you are bound by the same rules with very few exceptions, correct?
The statute speaks specifically to the question of the applicability of DOJ policies and practices and says, to the fullest extent practicable.
This morning you told the committee that, and this is on 49 and 50 of your own testimony, we have made every effort to follow the Department of Justice practice and policies, to utilize time-honored law enforcement techniques, and even on occasion that you and your staff, to use your phrase, would repair to the U.S. Attorney's Manual for guidance. You stated that this morning.
I did.
With these statements in mind, I would like to turn to the issue of your involvement with Monica Lewinsky on the first occasion that you had that ability, because so much of the evidence that the Congress has received comes from that first incident. It is true, I take it, Mr. Starr, that when press accounts of your interaction with Monica Lewinsky first arose, you made a statement to the press on January 23rd, 1998, responding to those allegations. And you can find that statement to confirm its date on tab 20.
Tab 20.
Do you see that?
I do.
You made that statement on January 23rd. Isn't that a fact?
Yes, I believe that's correct. This is dated January 24th, but I think it would have been the preceding day.
Mr. Starr, in your testimony this morning, you talked about the President's ability to provide misinformation, and you also said that one of the concerns of your office was that the President and his lawyers, on page 52 of your testimony, didn't give a, quote, distorted picture of the facts. With your own quotes in mind, I'd like to ask, don't you think your statement to the press, to the Congress, and to the American people gave a very distorted picture of the facts of the night and the day that you first confronted Monica Lewinsky?
Well, I think not, and we can obviously discuss it.
Well, let's do that line by line, because it will be short, but I
Yes.
think it will be elucidative. If you look at the first line of your press statement, it states, Monica Lewinsky consented to meet with several FBI agents. Do you see your statement that says that?
Yes, I do.
In Monica Lewinsky's sworn testimony, which if you'd like you could follow in tab 21 to compare it back and forth, we will have it on the stand as well. She testified under oath that she was there to have lunch with Linda Tripp. She was then accosted by agents who flashed their badges at her. She asked to see her attorney, was told that that wasn't such a good idea. She was then asked to go upstairs to discuss how much trouble she was in, and then she reluctantly went upstairs to meet with your staff. Do you think your statement that Monica Lewinsky consented to meet with several agents doesn't distort the picture of what really happened that day?
Well, I think it was it was consensual. That is, we made it clear that she was not under arrest and that she was, in fact, at liberty to make a decision as to what she wanted to do.
Well, if you look at the second line of your quote of your press statement, you said, during the 5 hours while awaiting her mother's arrival, Miss Lewinsky drank juice and coffee, ate dinner at a restaurant, strolled around the Pentagon City Mall, and watched television. Do you remember making that statement to the press?
Yes, I do.
But your statement to the press, Mr. Starr, doesn't include the facts that Miss Lewinsky swore to, that she was scared and was crying a lot of the time. When she asked to see her attorney, quote, she would not be able to help herself with her attorney there, she was told. That she was threatened with going to jail for, quote, 27 years. That she was not there for the 5 hours that your press statement says, but was there for over 10 hours. And that when she asked to call her mother to discuss what you were discussing with her, your deputy, Jackie Bennett, said, you're 24, you're smart, you're old enough, you don't need to call your mommy. That wasn't in your statement to the press that day, was it?
No, it wasn't, Mr. Lowell, and let me explain what press statements are designed to do. This was not designed to provide a verbatim transcript of commentary. They are designed to respond to what we were, in fact, being accused of or charged with. And what we were being accused of and charged with was improper conduct with a witness. Now, the facts of the matter are these. We did, in fact, use a traditional technique that law enforcement always uses. We were waiting patiently for her mother to arrive. She chose not to make a decision before her mother arrived. And at the conclusion of her time with us, she had established a legal relationship which we fully recognized and always honored, and she and her mother indicated, I was not there, but I am told they indicated their appreciation for the way in which she was being treated. Now, this was in response. This was being in response, Mr. Lowell, to allegations that she was being subjected to the kinds of conditions that would overbear the will. We then, and the purpose of this was to say, here is in fact material that the public should in fact know, and all of this is absolutely true.
When you say the public should have known that, and you state in your press statement that she was repeatedly told she was free to leave and that she did so several times, do you not think it would have been a less distorted picture, to use your words, to know that when she left the room she was followed by agents and that she swore under an oath that she, quote, felt threatened that when she left she would be arrested, end quote? Don't you think that completes the picture a little bit?
I think her perception was incorrect. We made it clear to the witness that she was in fact free to leave. And the Ritz-Carlton, shall I say, is a fairly comfortable and commodious place. We will show you, I'm sure you have them, telephone records that indicate she reached out to Mr. Carter, her attorney, in a totally different matter. She called her mother. She, in fact, went for a walk. She went to a restaurant and the like. And all these were important because, Mr. Lowell, what the office was being accused of was somehow overbearing her will. And she didn't need to make a decision because here's the other side of the picture. She was encouraging others to join her in committing perjury. She was, as the information came to us, a felon in the middle of committing another felony.
She wasn't likely, after being brought up to your room for 10 hours, to be committing any felonies anymore after that, was she? You said you needed to do this because she was in the middle of committing a felony. You don't think she was going to leave the hotel room, go back, and continue to do that which you brought her to the hotel room to do. You can't be meaning that.
We did not know. We had no way of knowing what she was going to do. What we did do is this, that we had a consensual recording. We shared the results of that consensual recording with the Justice Department. We informed the Justice Department of what our intention was at the Ritz-Carlton. We then proceeded in a very professional way. And then we were being met, as is not atypically the case, with charges of improper conduct. We then said we should respond to that, especially when, and this doesn't speak to that either, we were going to the conditions of confinement as opposed to whether we had communicated with the Justice Department. There was nothing in here about the Justice Department knowing that we were going to go have exactly this kind of encounter to ask this individual, are you willing to help us? We viewed her as culpable, but in discussions with the Justice Department, the culpability we thought might be outweighed by the culpability of others.
As you are the deliverer to this committee of the principal evidence that the committee is going to get, and as you agreed with me that the choices you've made bear on the substantiality and credibility, my questions were trying to go to whether or not when you make statements, when you provide information, you provide the complete picture, not whether Ms. Lewinsky was about to commit a crime, but I think you and I have established some of the facts that I wanted the committee to understand. One last point about your statement, Mr. Starr. Your statement to the press, as you alluded, indicated that when she was done with this ordeal, when she was done, she told the agents, and I think you said they thanked the FBI agents and attorneys for their courtesy. But you didn't put in that, and you didn't put in your referral, that she thanked them for their courtesy after, quote, they told me they were planning to prosecute my mother for the things that she had said she did. You didn't include the notion in your report to the press or even in the material in the referral that is later in the transcripts that part of her courtesy to her mother was threatening her prosecution. And that wasn't there either.
Mr. Lowell, the information that we had suggested that her mother may have been involved in serious activity, in serious criminal offenses. That was an issue. And she wanted to reach out to her mother to discuss the questions with her mother. We honored that. And no, I don't think that one would expect, if you're talking about the press release as opposed to the referral, that a press release which is responding to charges by her lawyers, that which she was being held, I don't want to put words in their mouth, but the substance of what was being conveyed by the very loquacious Mr. Ginsburg was that she was being held incommunicado. That was wrong. It was unfair to us, unfair to our agents, it was unfair to the Justice Department. But you don't see anything in the press release about the Justice Department either. The purpose of this press release, which you've identified as tab 20, and you've been kind enough to underscore it, was to respond to specific allegations. And I see you do not include the allegations to which we were responding. And I think in order fairly to assess this, you would have to say, what was it that the independent counsel's office was having to respond to? What we were responding to were allegations that were utterly unmeritorious.
And those allegations, Mr. Starr, were that you were overbearing, that she wasn't free to make a decision on her own, that she was put in a position where her judgment would be questioned, and you're saying to the committee that the facts as sworn to by Ms. Lewinsky don't bear on whether or not those allegations were indeed exactly accurate.
Oh, Mr. Lowell, surely you don't think that a witness is going to say, thank you, law enforcement, for finding out that I'm in the middle of committing a felony. Surely you're not going to say, surely you're not going to take the position that the witness should say, oh, I can't imagine why you're asking me any questions. I can't imagine why you're bothering me. The reason that she was being approached, Mr. Lowell, was that she was trying to get Linda Tripp to commit perjury, and since you've inquired about this, her mother had made it clear that she was willing to help finance an operation for Linda Tripp so she could leave the jurisdiction and thereby avoid being confronted in the Jones deposition. That's what this was all about. So you're focusing on a press release as opposed to a court document. Could I say one other thing? In fairness, the issues with respect to our conduct that evening have been litigated. You can ask, obviously, all the questions that you want, but usually, if a witness believes that he or she has been mistreated, if her rights have been violated, there's a place to go, and it's called the courthouse. And that's where these issues have been resolved, and they've been resolved favorably to us. We conducted ourselves professionally.
I take it sitting here today, you are completely satisfied that the picture of your involvement with Ms. Lewinsky, as you stated to the American people, and the effects it had on her evidence were accurately depicted in the press statement you made, even given the full sworn testimony of Ms. Lewinsky and her mother. You're satisfied about that?
About this press statement?
About your
No. Because this was written from, and perhaps I have been inartful in my response. This was a response to specific allegations being made by her attorney. It was not based on an interview of Ms. Lewinsky. We had no basis for knowing, in terms of our talking with Ms. Lewinsky, what her perception was. We couldn't. Her lawyer declined to allow us, and we honored that once she engaged Mr. Ginsburg. So the mission or the purpose of this press statement was simply to be as responsive as we should be at the time.
Just so that the record's clear,
yes.
Mr. Ginsburg is the lawyer you keep referring to. We know from the evidence that she contacted Mr. Ginsburg only after her mother arrived about however many hours later in the middle of the night. And the very first thing she said when approached by your agents in the lobby was, "I want to talk to my attorney, Frank Carter." You don't mean to suggest to the committee that you and the agents and the people in your office was encouraging her to talk to her lawyer between the time that she was first accosted and the time that she got on the phone with Mr. Ginsburg. You're not making that statement, are you?
That is correct. We would not encourage someone who was involved in felonies, as we thought at the time, to in fact reach out to a lawyer, especially a lawyer who had assisted her in crafting a perjurious affidavit. Why would we possibly do that?
Well, one reason would be because the rules of the Department of Justice, the law of the land as decided by the Supreme Court, and the Code of Federal Regulations require it. Let me turn your attention to tab 23. On tab 23, as I understand it, Mr. Starr, one of the people that were in the room asking questions of Monica Lewinsky was a deputy of yours by the name of Michael Emick. Is that right?
That's correct.
Michael Emick came from the Department of Justice U.S. Attorney's Office in Los Angeles, California, and had had the opportunity 3 or 4 years before the Monica Lewinsky incident to give a speech or give a presentation to the Department of Justice about what the law requires. And this is what Mr. Emick said about questioning a witness represented by counsel. He said, "It is rarely okay to contact the person, find out about representation, and ask if he is willing to talk anyway." And then Mr. Emick went on to state, "It is never okay to continue to ask questions after the person has said he wants his attorney there." In light of what the transcripts show happened that night to Ms. Lewinsky, it appears, does it not, Mr. Starr, that the deputy involved violated his own words in his effort to get Ms. Lewinsky that night?
No, because you're assuming something, and you are, with all respect, incorrect. She was not represented for purposes of this analysis. And the reason that she wasn't, and you may disagree with this, but here is our analysis, and it has been upheld by the district court. Let me approach it this way. If one has a bankruptcy lawyer, one cannot say, if an FBI agent comes up to one, "Well, I am represented by, or the FBI agent must assume that I am represented by, or the person is represented by the bankruptcy lawyer. The point is, there's a very clear distinction in the law and in the rules of ethics between civil matters and criminal. And Mr. Carter was representing her in the civil matter.
But when I realized up to that point she had no criminal problems. She only had civil problems, which she had a lawyer for. So you're saying it's the prosecutor who tells a witness whether or not she or he has the right to call a lawyer based on the prosecutor's decision as to whether or not the matter is civil and criminal in the prosecutor's view of how the proceedings are going to go. Do you think that's what the law states?
Well, I think the prosecutor has to make a judgment as to whether the nature of the representation is civil or criminal, so that the person does have to know whether, in fact, the party is a represented party. That is a judgment. Now, even if you disagree with that, Mr. Lowell, let me say these two things very briefly. One, she did, in fact, call, or we sought to call Mr. Carter from the Ritz-Carlton. That's a very important fact. She did, in fact, reach out to him. Also, we tried to reach out to legal aid so that she could have counsel. She later got, of course, Mr. Ginsburg. So the idea that she was not, in fact, permitted the opportunity to try to consult with counsel is incorrect.
Mr. Chairman, I'm in my last area of questions, and I would appreciate the committee's indulgence.
How much more time do you anticipate?
Well, I know my questions take 5 or 10 minutes. The answers always take twice as long. I suspect I have
Well, you
about 5
ask
or...
such complicated questions.
Mr. Chairman, I have one more area to get into, and I'd appreciate the committee's indulgence to get there.
Well, I'll yield you five more minutes and see what you can do in 5. I'll ask Mr. Starr if you can be concise, although I'm enjoying your answers myself. Mr. Lowell, for 5 minutes.
Thank you, Mr. Chairman. In the end, Mr. Starr, you have said that these are serious matters that the committee has to consider, and that you've come here today and you presented again what you deem to be the evidence and the conclusions in your referral. I just want to, if I can, with you and with the committee's now indulgence, go through the principal charges that you made in bringing this matter before the committee. In the first matter, you say that in your referral, in your testimony today, that the President lied under oath on a variety of occasions having to do with the Paula Jones case. I noticed on pages 8 and 9 of your testimony, you spoke about Judge Weber Wright's rulings in the Paula Jones case. But in your testimony, you did not also include, did you, that Judge Wright had ruled as to Monica Lewinsky's significance in the Paula Jones case, that it was, quote, not essential to the core issues in the case. She ruled indeed later on that the evidence, quote, simply was not essential to the core issues of whether Paula Jones was the victim of a quid pro quo sexual harassment. And she finally threw out the case on the grounds that Ms. Jones had not proven what the law requires. And I wanted just the record to be complete that when you talked about what Judge Weber Wright had ruled in your testimony, you never mentioned that on 3 occasions Judge Wright made rulings indicating that the significance of whatever it was between Monica Lewinsky and the President did not bear on her decision. That's a fact, isn't it?
Well, I disagree with the characterization of what she ruled, and I will simply refer to her 2 opinions, including her analysis under Rule 403 of the Federal Rules of Evidence. I don't think that's a fair and accurate characterization of what she ruled. We may have a different opinion of how she adjudicated the matter.
Then as to the issue of the false affidavit, which you state was something the President was complicit in to the extent that it was a ground for impeachment, your evidence also includes, does it not, Mr. Starr, that Ms. Lewinsky gave you a statement in which she said, quote, neither the President nor Mr. Jordan or anyone on their behalf asked or encouraged her to lie. And you can find that in tab 35.
Tab
35.
35. Thank you.
You're aware that she has made the statement that way by now, I assume, right?
Yes.
You must be aware that she also said that she offered to show her affidavit to the President, but he did not even want to see it. You're aware that that's the testimony that she's given as well, correct?
Yes.
You must also be aware that she explained to you that the President and she had obviously used cover stories from the beginning of their relationship long before she was ever listed as a Paula Jones witness. You're aware of that as well, aren't you?
Yes, and our referral makes that point clear.
As to the issue of whether or not she was given a job in some way to keep her happy, you know the evidence that you sent Congress includes the fact that the job search for her began long before she was listed as a Paula Jones witness, correct?
Yes, absolutely, and we make that clear in the referral.
And you are also aware that she told the president in July, months before the Paula Jones...
July of...
1997.
Yes, thank you.
Months before the Paula Jones case was an issue, that she was going to look for a job in New York.
Yes, you did.
And you're aware as well that it was Ms. Tripp, not the president, Ms. Tripp, who suggested to Ms. Lewinsky that she bring Vernon Jordan into the process. You know the evidence says that, don't you?
I am aware of the evidence with respect to that, but yes, go right ahead. I'm sorry.
You're aware as well that the evidence you've sent Congress indicates that on that crucial issue, as others have stated, and I'm no doubt will state again, Ms. Lewinsky unequivocally, even though never asked the question, stated to you that no one ever asked her to lie, no one promised me a job for her silence. You understand she swore to that as well?
Yes, and Mr. Chairman, may I respond? I'm trying to be brief, but Mr. Lowell, as you also know, at page 174 of our referral, we specifically say Ms. Lewinsky has stated that the president never explicitly told her to lie.
I understand that you say explicitly. I'd say that Ms. Lewinsky's statement that, quote, no one told me to lie, no one offered me a job for my silence, is not equivocal. Would you?
I would say that it is utterly incomplete and grossly misleading. We try to capture that, and I'm, of course, staying right now with respect to the her representation with respect to no one told me to lie. Her entire testimony is to the effect, and I think this is a fair characterization of it, is that the cover stories were in fact going to continue, that was the understanding. But yes, no one explicitly said, you know, you will lie, using the L word. Rather, it was, we will continue with cover stories which were not true.
I have one last question, Mr. Starr, given the limits of time under which I've been placed.
I'm going to have a surly bunch of Republicans.
It is my last question, Mr. Chairman.
Go ahead, ask your last question. Please, go ahead.
Didn't you feed them?
It was
Not with what they want.
no, it was a very
Did I hear
short
Charles
lunch break.
Schumer here?
Last chart. Summary chart. Mr. Starr, I don't have the time to get into the areas, and hopefully the members will, but I will ask you the last question. It's the one I started with. When you suggested to the committee that what you did, the choices you made, have to be looked at to determine the substantiality and the credibility of the evidence, I want to ask you whether or not you don't now see, based on the things that we've discussed, that the manner in which you decided to write the referral as one with attitude, your contacts between you, your law firm, and Paula Jones attorneys, the questions that have been raised about whether or not you got into this case with proper jurisdiction, the way you dealt with Monica Lewinsky and the evidence that came from that, Judge Johnson's orders, which some others will talk to you about whether your office has been responsible for leaks, and the contradictions in the evidence between your referral and the statements you agree are in the evidence, doesn't that undermine the substantiality and credibility of the evidence on something as weighty as impeaching a president of the United States?
Mr. Lowell, nothing that you have said, and with all respect, what you have done is go into characterizations as opposed to deal with facts. The facts are as we have found them to be, and not one of your questions suggests that the president was not involved in serious offenses that now is your responsibility to evaluate. In terms of the letter, I believe, with all due respect, you have overread the letter. I do think if there were any suggestion that we had compelled a confession from her on the evening of January 16, that would go forcefully and powerfully to whether any such statement by her should be used. But Mr. Lowell, she was treated in such a way, she did not make a statement to the officers.
Thank you, Mr. Chairman.
Thank you. We will now move to the members' questioning, and the chair recognizes under the 5-minute rule, we'll try to adhere to it. But again, I will be liberal, but I would like you to make your questions concise. Mr. Sensenbrenner.
Thank you very much, Mr. Chairman. Let me say that the clock does not run slower on this side of the table as apparently it does over on the other side. I was struck, Mr. Chairman, that for the first hour plus, Mr. Lowell's questions completely avoided and evaded the principal charges that have been in your referral, Judge Starr. And only after his second extension in the last 5 or 6 minutes did he get to the charges that specifically allege misconduct by the President of the United States. I would hope that during these proceedings, the rule of law is not on trial. That is something that has served our country well for over 200 years. The rule of law, I think, is paramount, and with the rule of law goes the notion that everybody stands before the law equally, whether they be president or pauper, whether they be powerful or poor. So, having said that, let me ask you, Judge Starr, whether you believe that there is any difference in the law of perjury and the law of making false statements to a grand jury just because they happen to relate to sexual matters.
They do not, Mr. Sensenbrenner, as I have tried to indicate in the opening statement, as we've indicated in the referral. Perjury is extraordinarily serious business. It is insidious. The courthouse cannot operate if perjury is allowed to either be excused or to be minimized. And why should we, in fact, go through the process of saying there is an oath, we want you to tell we want your honesty. That's what we ask in court. We want your honesty. And it does not matter whether the issue has to do with sexual harassment or bankruptcy or the criminal law. It is all dreadfully serious. And in my reading, I know that there is scholarly commentary to the opposite effect. Perjury would in fact have been viewed as an impeachable offense at the time of the founding of the Republic. And courts from that time on have taken perjury as extraordinarily serious, regardless of the kind of case.
Judge Starr, folks back home have come up to me and said, why don't you drop this whole impeachment thing, because everybody lies about sex and the president ought to have the opportunity to lie about sex just like everybody else. I'm concerned about the impact of that attitude if it ends up being adopted around the country on a lot of essential protections that the law provides, particularly for women. For example, every sexual harassment suit is about sex. That's of its very nature. And much of our litigation, both civil and criminal, of domestic violence has at least some element of sex involved in it. If people can perjure themselves in court about sex, don't you think that that makes our sexual harassment laws and our domestic violence laws less meaningful and in many cases unenforceable?
Yes, well, it certainly makes them, I agree fully that it would make them less meaningful, and it would certainly make it much more difficult to enforce if we did not take acts of perjury or obstruction seriously in this particular category of case.
I have one further question which has been referred to before. There are some that have said that the testimony about Monica Lewinsky in the President's civil deposition in the Paula Jones case was not material as a result of an order which you obtained from Judge Wright right after the expansion of your jurisdiction into the Lewinsky matter. Could you please describe what that order did and why you sought it and what its effect was on those allegations of perjury and false statements that you made in your referral relative to the Jones civil deposition?
Yes. Number one, we tried to put a stop quickly, immediately, to the Jones lawyers' efforts to notice depositions of witnesses in our grand jury matter. Mr. Chairman, may I just, I'll make this
Surely.
very brief.
Surely. That's more a restriction on the questioner
Oh, I
than
see.
a questionee. But,
You may regret that because I
please.
Yes, thank you. Thank you, Mr. Chairman. But we went to the judge, and the judge, and we asked for a stay of discovery, and the judge, in response to our request for a stay, then went on to determine, under an analysis that I was trying to describe to Mr. Lowell's apparent irritation, Rule 403, but it was the issue that Judge Wright was wrestling with, which is a weighing or balancing process, and she determined that this evidence, although possibly admissible, should be excluded because the dangers to the criminal justice process, I mean, her order should speak for itself, and I shouldn't be paraphrasing the judge's order. The point is, she responded to our concern when we were trying to vindicate the integrity of our criminal justice investigation.
Gentlemen,
But that has no, I'm so sorry.
Go
That
ahead,
was point
finish.
one. Point two, that has no effect whatsoever on materiality, which was the second part of your question, because that is a legal concept that fortunately is very consistent with common sense. Materiality is measured at the time that the statement is made. It doesn't matter what eventually happens in the lawsuit.
Gentleman's time has expired. The gentleman from Michigan, Mr. Conyers.
Thank you very much. Mr. Starr, it's very clear under this process, which many of us do not agree to, that trying to question you for 5 minutes is a ambitious and hopeful undertaking that doesn't quite achieve our objectives. Would you be willing to respond to additional questions should the time run out on us to these other questions that might be put to you in a written form?
We're trying to be as helpful as we can, so if there are written questions, depending on the chair's ruling, whatever the chair determines is appropriate, because I don't know.
Members may submit written questions for the record. I'd like to establish a deadline for the questions and for the responses by Judge Starr so that the questions and answers may be included in the record before our authority runs out.
Thank you very much.
What deadline would the gentleman from Michigan suggest?
I don't have one right now, but could we agree on one very shortly? A week.
Okay, without objection, questions shall be submitted in a week, which happens to be Thanksgiving, and the responses within a week. Is there objection by members of the committee? Hearing none, so ordered.
Mr. Chairman, reserving the right to object, my only concern is, that, if I may address the reservation, my only concern at this point is that the request as phrased by my friend from Michigan theoretically could be an invitation to an open-ended, encyclopedic presentation of questions to Judge Starr that neither he nor his office will have the appropriate amount of time to respond. I'm assuming that if questions are propounded to Judge Starr's office...
Could I allay my friend from California's problems in his reservation by saying that all I seek is a full record so that no member has been cut off from a question that they should try to ask within the 5-minute rule on inquiry on the impeachment of a president of the United States.
I thank my colleague's clarification. My assumption, Mr. Chairman, is that with unanimous consent, that also comes a degree of reasonableness, and if there is a problem with Judge Starr's being able to propound answers in a timely fashion, he would be able to notify the committee, and we would be able to review this issue again.
Absolutely,
Exactly.
and the chair, or the acting chair, would request that members funnel their questions either through Chairman Hyde or Ranking Minority Member Conyers rather than firing them off directly to Judge Starr.
I thank you for the order. I thank you for the interest.
Gentleman from Georgia.
Unanimous consent. What exactly are we being asked for unanimous consent on? I'm not sure I understand.
To allow written questions by...
To the independent counsel, and he has to answer them within a week?
A week, yes.
I object.
Objection is heard.
Well,
I have told your 5 minutes, so the gentleman's recognized for 5 minutes now.
well, we just went through a process which we had, I thought, agreement. What we're doing here then, ladies and gentlemen, is saying that within a 5-minute period, 16 members, including Mr. Starr's response, have 5 minutes to ask him anything that they want. I think that this is patently unworkable, and all I suggested was an additional method of communicating with you in writing, sir.
Well, if the chair can respond to that, the rules of the House of Representatives in these instances provide for recognition of members for 5 minutes apiece. And the chair at the beginning of this hearing today said that members would be recognized under the 5-minute rule. So far, there have been only 2 people who have spoken, Mr. Lowell, who received 2 extensions, and yours truly, who got his questions in within 5 minutes. Now, I don't think we want to be staying here until midnight. I would hope that the 5-minute rule, which seems to have worked well for decades, can be adhered to and members can be concise. So again, I will move the clock back to 0, and the gentleman from Michigan is recognized for 5 minutes.
All right, it's clear to me that some members do not want a full and open discussion with the witness, the only witness here today. So let me just propose. Yes, ma'am. No, I was going to my questions, but I'll yield to you if you'd like.
Well, no, it's just that the chairman is back, and I'm not sure that he was privy to your request.
Have you yielded to her? Because this is your
Yes,
time.
I did.
Well,
I did.
Okay, that's all right. You want to submit written questions to
Yes.
the
Well,
witness?
That's the only point, sir.
Well, I have no objection if he has no objection, but I would like them, they would be returned when we hear from the president. How's that? A simultaneous return of questions. Is that a good idea?
Well, I don't know if we should condition our questions to Mr. Starr on whether the president and his counsel have chosen to raise whatever questions you have with him.
The gentleman yield.
Of course I would.
I would simply point out that the request for the ability to submit written questions is made on behalf of members of the House on this side and presumably the other side of the aisle. We have no control over whether the president testifies. It's up to him, and the 2 subjects are separate.
You do see the wisdom, the fairness, though. That's a big word around here.
No, I don't. I don't see the fairness, frankly.
You don't?
The president will testify or not as he determines. It's his determination in this proceeding. And frankly, the ranking minority member suggested that it would be helpful to the members of this committee in ascertaining the facts and having a full and fair proceeding that we have the opportunity to submit written questions in addition to 5 minutes. I think that's reasonable, but it's either reasonable or not reasonable, regardless of what the president chooses to do in his own capacity.
Well, Mr. Nadler, I thank you very much. The chairman has made it clear that conditionally we can send Mr. Starr questions. Another member on the other side has made it clear that he doesn't want any questions and answers whatever in writing. And so I think the point has been made. I'd like to just go ahead and try to utilize my questions and answers within the period of time that I have. Mr. Starr, I'm concerned about the potential conflicts of interest between your public position seeking to impeach the president and your private positions representing numerous clients whose agendas are aligned directly against the president. Can you assure this committee that you will provide us, for our information, a complete list of the clients in your distinguished law firm, or that the law firm that you were a member of, that you have represented since accepting the position of independent counsel?
Yes.
Thank you very much. I'm particularly interested, of course, in the matters with the Brown and Williamson Tobacco Company, General Motors, Hughes Aircraft, United Airlines, Bell Atlantic, and a number of others. But thank you so much. I can go to a second question. The grand jury leaks. in reviewing your statements concerning this subject, we have two reports. I can ask you about them now. You didn't mention them in your reference to us. Namely, once in the Washington Times you were quoted as having said the release of any investigative information by a member of this office or any other law enforcement agency would constitute a serious breach of confidentiality. This summer, it became clear that your office had spoken to reporters on background, developed a different standard, telling Stephen Brill, quote, "Nothing improper about leaking if you are talking about what witnesses tell FBI agents," end of quotations. This to me is quite important. Is there a distinction or a compatibility with both those statements, sir?
Yes, in this sense, I'll be very, very brief. We have responded in detail to the article that you mentioned, and I would be happy to provide that to you. I think it's all laid out there. My position is this: we do not issue or release that kind of information. That is our position. Now, what does the law reach? The rule of 6E is an issue that I'm sure we'll be discussing later today.
Yes, under the 5-minute rule, we may or may not discuss it. I mean, that's the problem. Doesn't your sense of fairness in the courts extend to congressional hearings where you have 16 members with 5 minutes to ask and be answered questions? Doesn't that strike you as somewhat constricting, somewhat limiting, somewhat hard for us to take the advantage of your appearance before us as the witness of the day?
Mr. Conyers, I do not want to speak to the rules of the House. May I answer 6E? Because I gather that my answers, which do not count against your time quite in the same way, but I will be guided by you.
Well, let me ask you about the Travelgate and FBI files, which you did not mention the exoneration of the president in your reference. Why did you include any exculpatory information in your reference, and why didn't you put it in there instead of putting it in your statement here?
We put the statement here. You're right. We did not include that in the referral because of my views of what the referral was supposed to do. What I viewed this invitation as being was to try to, because I was invited, and pursuant to that invitation, we reflected on what is the information that you might need, because we have been told, Mr. Conyers, by the Congress, don't be holding things back. If you have information that could be relevant, provide it. And that's what we have, in fact, been trying to do. Now, if there's a sense that we're providing too much information, we'll be guided by that, because we're trying to be helpful.
Well, I thank you very much for that response.
Thank you.
And finally, sir, the failure to rule out pardon of Susan McDougal, is this a very strong or personally held sentiment on your part? We had President Bush pardon 6 defendants in Iran-Contra, and I was a little bit dismayed that you would deem fit to blow out of proportion the fact that the president refused to comment on the possibility of pardoning Miss McDougal. Did I read more into that about your attitude about her than I ought to have?
No, Mr. Conyers, I think you read it fairly and accurately, and you might very well have a different view that my view is quite wrong. But our view at the time was that the president did not help the situation of our trying to get to the truth as quickly as possible by his comments. But that's your judgment. We have brought that to your attention for you to assess, and if it's your judgment that is not an appropriate matter to consider, or your judgment is different, obviously it's your judgment that controls and governs here.
Well, I'm glad to know that that's the case, that I still have my judgment intact. Thank you very much.
The gentleman's time has expired. I might say on the 5-minute rule, that's pursuant to the rules of the House, and the Republicans get 5 minutes just like the Democrats. So there is an equal burden. We have been extremely generous in questioning, and I don't intend to shut anybody down, but I hope the seating arrangement suits you. That's about all that hasn't been complained of today, and I just hope it's okay. We'll change it if you want it. Hassix, very good. Very good, I like that. The gentleman from Florida, Mr. McCullum.
Well, thank you very much, Mr. Chairman. And Judge Starr, I'm sure in light of that, you should be fully aware that Chairman Hyde keeps the time. You answer the questions as fully as you want when we ask them. We'll get our bell rung, but don't worry about your bell.
Thank
Now,
you.
let me come on and ask you a couple of things just to follow up quickly. At any time, did you ever represent anybody in the Paula Jones sexual harassment case?
No. Well, I shouldn't be so quick. I did not represent ever Ms. Jones or even seriously contemplate anything other than a role with respect to the constitutional immunity issue. But I believe, and I can check this, but I'll just give you my belief, that my firm did in fact represent the Independent Women's Forum.
Right, but you never personally represented anybody in the Paula Jones sexual harassment litigation per se.
Not per se. No,
This is the immunity question. That's all I wanted to clarify.
Okay.
You engaged us very fully on the immunity issue during your complete testimony. I have another question that's related. I heard you describe this morning a compelling picture of President Clinton, a compelling picture of him acting in a cold, calculated, methodical, well-thought-out method, a scheme, if you will, to lie under oath, to commit perjury, if you will, with regard to his involvement with Ms. Lewinsky before the Jones case, in the Jones case in the deposition and before the grand jury, to convince Monica Lewinsky and Betty Curry to also commit perjury, lie under oath in that Jones case, to work to get him, others perhaps, but certainly in concert with him, to conceal and not produce the gifts that you mentioned in a subpoena situation in the Jones case where they were subpoenaed of Monica Lewinsky, and to try to get Monica Lewinsky a job in at least, it appears from circumstantial evidence you described in a compelling way, in large measure because the president wanted to keep her from turning on him and to keep her from going ahead and telling the truth at some point. Now that is a picture you painted. It was very compelling. Now, the latter part interests me. Section 201 of Title 18 of the United States Code is the bribery section of the code. And it reads in part, whoever directly or indirectly gives, offers, or promises anything of value to any person for or because of the testimony under oath or affirmation given or to be given by such person as a witness upon a trial, hearing, or other proceeding, etc. Couldn't a reasonable person, Judge Starr, listening to what you described, particularly with regard to the job offer, the circumstantial evidence the president has of obstructing justice in that instance as you described it, couldn't a reasonable person, a reasonable member like me, conclude that there may, as well as being obstruction of justice here, may be an act of bribery the president committed in this case? Could I not conclude that as well?
Well, Mr. McCullum, I would not want to join in a particular judgment beyond that which we have set forth in the referral. But you will obviously go through your analysis. I think on the other side of the equation are the circumstances when the job search began and so forth. But I have frankly not taken the specific issue you have identified, and it's a fair issue, through the kind of elements analysis that a lawyer and a prosecutor would need to do. So I think in fairness, I would say I would just want to examine that question more closely before opining on it.
When you actually testified this morning, all of that went through my mind. I pulled out the statute book, I've walked through it, and while you didn't allege it and you aren't here today, it seems pretty darn clear. And I think that's important because in the context of this picture you're painting of the president, you're painting perjury and bribery, as you've said, as of the same whole cloth. We're dealing with a similar pattern. we're dealing with an involvement that overall is very grave. And I'd like to conclude with a question that amplifies and gets you to clarify one other thing that Mr. Sensenbrenner asked you about regarding the issue of perjury itself. In this particular case, a number of our colleagues on this panel have suggested that because the Paula Jones case was dismissed and ultimately settled, or because there was indeed a throwing out by the judge, albeit appealed, of the underlying question of whether or not there was any relevance to the testimony about other people being sexually harassed as being relevant to that case, that somehow, therefore, if the president lied in that case, it's immaterial. Now, you started to say something about that. I don't think you really fully put the nail into this, and I'd like for you to tell us, in your judgment, based upon what you presented us today, were the elements of perjury present when the president lied under oath, as you've described it, in that Paula Jones case, and particularly was materiality present?
Materiality is not affected. It is a totally bogus argument to suggest that because the lawsuit is eventually settled or dismissed, that an act, let's call it perjury, we've said, a false statement under oath. That's the way we presented it to you. That is simply and utterly, demonstrably wrong as a matter of law.
But that
The gentleman's time has expired.
But may I just clarify one thing, Mr. Chairman?
Yes.
The false statement under oath you presented and the way you described it with all the elements there, you've described all the elements of perjury, have you not, Judge Starr? You may have distinguished it in the way you presented it, but aren't all the elements there you just described?
I'm not quarreling with what you've just said.
Thank you.
The gentleman from Massachusetts, Mr. Frank.
Mr. Starr, Judge Johnson has found 24 instances of prima facie violation by your office of Rule 16. Now, that's not determinative of whether or not they happen, but so I'd like to ask you, are you aware of any member of your staff who, in fact, committed a violation as defined by Judge Johnson? Are you aware in any of those 24 instances whether or not a member of your staff, in fact, was guilty of what Judge Johnson has found to be a prima facie violation?
We do not think that we have violated 6E at all.
No, specifically on the 24 instances, because you may differ with her in part about how you define 6E, but as she defines 6E, are you aware of any member of your staff who committed a violation as she defined it?
Well, with all respect, I think that is an unfair question, and the reason I do...
All right, then I'll withdraw it. Mr. Starr, you're the expert in unfair questions. If you tell me it's an unfair question, I'll withdraw it. So let me ask again. Did anybody on your staff, to your knowledge, do the things which Judge Johnson has included in her list of the 24? Understanding that you may think that if they did, then they weren't violations. But did anybody in your staff give out that information on any of those 24 instances?
There are a couple of issues or instances in which we issued a press release where we do have, we clearly issued a press release with respect to certain matters. But may I say this? I am operating under a seal litigation proceeding, and
sealed by whom?
What I'm trying to suggest is I'm happy to answer as fully as I can, except with respect...
If you're suggesting that you can't answer under this particular proceeding, it's sealed at your request to the extent that it's sealed at all, so you could waive it. That is, Judge Johnson granted a motion for an open procedure. You appealed this to the circuit court, and they closed it up. So if you didn't object, nobody else will. So, I mean, if you didn't do any of the leaking, why not just tell us if it's wrong factually? And if, on the other hand, you're going to say, well, you successfully got the circuit court to seal it, I suppose I can't do much, but I don't understand why you wouldn't just tell us.
Let me make very briefly these points. We believe that we have completely complied with our obligations under 6E.
It wasn't my question, Mr. Chairman. I only have 5 minutes. My question was whether, as Judge Johnson set it forward, they did this. They can differ with her as to the law. I'm not debating the law here. I was trying to elicit a factual response.
The second point that I was trying to make is that I am operating under a sealed proceeding.
Sealed at your request, correct?
No, Mr. Frank. It is sealed by the Chief Judge based upon her determination of...
But, Mr. Isn't it the case that she asked for, she granted a much more open proceeding and you appealed that and got the circuit court to severely restrict the procedure on the grounds that hers was too open. Isn't that true?
Congressman Frank, what she did was to provide for a procedure that didn't provide, quote, openness. It provided for an adversarial process, and this is all in the public domain.
Right.
But from this point forward, no. She is the custodian and the guide with respect...
Would you ask her to release that? I think there's a severe, important public interest in dealing with this leak question. It goes to the credibility of a lot of what you've done. Would you then join, maybe everybody would join, maybe the White House would join and others, in asking Judge Johnson to relax that so we could get the answers publicly? Because I think there's a lot of public interest, legitimate interest in this.
I am happy to consider that, but I'm not going to make, with all respect, a legal judgment right on the spot with respect to a proceeding.
Well, then let me...
that is,
you have right now, too. Now I just want a couple other questions. You say in page 9 of the referral that 595 suggests that you send us information based on a referral as soon as it becomes clear to you. That's what bothers me about the FBI file and travel office issues. You say on page 47 of the testimony, our investigation, which has been thorough, found no evidence that anyone higher than Mr. Livingstone or Mr. Marcesta was involved. When did your investigation determine that?
well, under 595C, we
That's a simple factual question, Mr. Starr. When did you determine that?
determined that
That nobody higher than Mr. Livingstone or Mr. Marcesta was involved?
we've determined that some months ago.
Okay, well before the election. You also have, with regard to the travel office, a statement that the president's not involved. When did you determine, with regard to the travel office, that the president was not involved?
We
That's
have
factual, Mr. Starr. When?
it is not a date certain. We have no information with respect to.
I'll take a date ambiguous. give me an approximate.
We have. First of all, there is an investigation that is continuing, and as of this date of reporting, we do not have any information.
All right,
that
let me
the
just say this, and
president
here's
is
what
involved.
disturbs me greatly. You say on page 9 that, yes, you should send us this information. Before the election, you sent us a lot of information about the president that was to his discredit in some cases, and you found it very derogatory in other cases. You also had been studying for far longer than the Lewinsky case, the FBI and the travel office. You tell us that months ago you concluded that that the president was not involved in the FBI files, and you've never had any evidence he was involved in the travel office, yet now, several weeks after the election, is the first time you're saying that. Why did you withhold that before the election when you were sending us a referral with a lot of negative stuff about the president, and only now, despite your saying that the statute suggests you tell us as soon as possible, do you give us this exoneration of the president several weeks after the election?
Mr. Frank, what we have tried to do is be responsive to Congress, which has said, provide us with information. Is there any other additional information that would be useful?
Well, why didn't you tell us before the election about this, according to your reading of the statute?
Congressman Frank, the reason is because what we provided you in the referral is substantial and credible information of possible potential offenses. The silence with respect to anything else means necessarily that we had not concluded.
In other words, don't have anything to say unless you have something bad to say. You've concluded in the FBI files. You said you concluded in the FBI files that there was nothing involving the president. Why didn't you tell us?
Point of order.
The gentleman's time has expired. However, I would yield to the witness such time as you need to answer the many questions Mr. Frank has put to you.
Well,
Go ahead.
Again, there is a process question. The purpose of this referral was to provide you with what we had found, substantial and credible information. That's point one. And the FBI files and the travel office matter were not relevant to the 595C substantial and credible information in terms of providing this to you. For you then to determine, do you want any additional information? The final point I would say is, we still have an investigation, as I indicated, underway. And with respect to both FBI files, we have indicated that, and the travel office, I've drawn a distinction between the two matters, but I'm reporting to you so you know that as of this time, we do not believe that there is any information in either of those matters, Congressman Frank, that would be relevant to you.
The gentleman from Pennsylvania, Mr. Geekus.
I thank the chair. Isn't it true, Judge Starr, that you did release before the election, months before the election, what amounts to the exoneration of the president with respect to the Vince Foster matter? Is that correct?
Yes.
Months before the election. And may I ask you this? in what form did you exonerate the president? What formal step did you take in the Vince Foster matter to end that case? Do you report back to the Attorney General?
In that particular instance, we issued a report, we filed it with the special division, and then made the report public so that it could address what we saw as these lingering questions with respect to the cause of death. It was a suicide by Mr. Foster.
And you felt comfortable in exonerating the president?
Oh, yes.
Mr. Conyers, my friend John from Michigan, went through a litany of tremendous clients that your law firm represents. In fact, when I finish my tour in Congress, I'd like to talk with you if I could. But may I ask you this? Was your law firm, were you a part of that law firm that represented these clients when you exonerated the president in the Vince Foster matter?
Yes.
Were these clients still on the books of your firm when you came to the conclusion that there was no connection in the Filegate matter to the president?
Yes.
Was your law firm and you involved in these tremendous clients that were mentioned at the time that you made a decision that there's probably no connection in Travelgate directly to the president?
Yes.
I thought you'd answer that. I am disturbed about something, though, that I found right from the first moment that I reviewed your referral, and that was the emphasis you put on with respect to what you would characterize as the misuse of executive privilege by the president. On page 204 of this version of the referral, you make a separate allegation that the president's actions were inconsistent with his constitutional duty to faithfully execute the laws, and you put in there that he did fail in that regard because he continuously used executive privilege. The first thing that I thought was, and I have not been disabused of it since then, is that the mere assertion by the president of a right like that, even if he objectively could be said knew what the result would be ultimately by the Supreme Court or appellate courts, I do not find that automatically or prima facie or even now at this latter stage of the proceedings to be something that the president should be debited on this case. But then my mind was settled a little bit when you said in your testimony that even apart from the matters concerning executive privilege and the like, you did feel very strongly about the questions of perjury. And just like many of us, it is going to be very difficult for us to set aside that deep emotional feeling that we have about the construct of law enforcement and the judicial system in our country. I can set aside any abuses of power, if they are called that, with respect to the assertion of executive privilege. And I ask you now, didn't you sort of prioritize in that regard when you said, setting apart the questions of executive privilege, you too feel strongly about perjury as an element in your referral?
Yes, Congressman, I would say these things. One, we believe the issues with respect to false statements under oath and the like are very serious, and the facts are there for you to evaluate, and you are evaluating those. With respect to the abuse of power, it is a judgment call, and you have come to at least your tentative judgment, and obviously, as I said to Congressman Conyers, it is now your prerogative to come to your own considered judgment as to what is right and not. May I say very briefly on executive privilege, I do think that it is an abuse of a very important constitutional principle. For such a special principle, executive privilege, which I strongly believe in, and I defend the concept of executive privilege, to be invoked with respect to the non-official activities of the President of the United States, I think it's improper. But it is your judgment that controls and not mine.
I ask unanimous for 30 seconds.
Without objection, much.
Without much objection. But can we not come to the conclusion in evaluating the executive privilege asserted by the president that he might have felt on any one of them where he exerted it, that to give him the extreme benefit of the doubt, that he felt that the office of the presidency had to be protected even in mundane or other matters which you find could be a misuse of power?
I'm sure that is the view of the president, and we came to a different view, but as I say, it's now your judgment.
I yield back the balance of my non-time.
Yes, I thank the gentleman. The chair will declare a very short recess till 5 minutes after 4 to give everyone a little stretch. And if you will please wait and let Judge Starr leave the room first. And then we'll be back at 5 after 4. Couple of little commentaries, if I may. When you watch a football game on Saturday or Sunday, you notice they have a 2-minute warning and these scheduled interruptions. Well, now congressional committees have the same situation. We have to give a 2-minute warning to the network television, and so that's why we seem to be suspended up here doing nothing. We're waiting for the appropriate time. The chair would like to announce we're going to finish this evening. Some of you may be wondering how long we're going to go. I have no idea. But rather than come back tomorrow, we're going to do the job today. So I plead with my fellow members, if you have to ask a question, I hope it's a burning issue with you and not something just of idle curiosity. And I'm looking at you, Mr. Delahunt.
I'm not idly curious. Are we going to take a supper break?
No, we won't take a supper break. We'll go straight through. We'll keep the jury locked up without food and water, right?
We're sequestered, I take it.
That's right. You may send out for pizza.
For everybody.
There will be a meeting. There will be a meeting after Judge Starr has completed his testimony. We will then have we will have a full meeting of the committee to do some business on subpoenas. So just be advised. And now,
Around the mall, will a police officer accompany us?
if you're walking around the mall, I would want 2 police officers. It is now a mixed pleasure to ask the senator-elect from the great state of New York and one of our very valuable members, whom we will miss, Charles Schumer, to interrogate, question our witness. Mr. Schumer.
Thank you, Mr.
For 5
Chairman.
minutes.
And I will miss you in this committee. Not so much today, but for many of the other things that we have done together. Today, Mr. Starr, today after nearly 5 years of investigation, we conduct today's impeachment hearing, having just received boxes of new documents from your office concerning Webster Hubbell, and have just learned from the chairman that we will be voting on deposing new witnesses involving the Kathleen Willey matter. And Mr. Chairman, I would say this to all of us on this committee, maybe we should hang a sign outside the Judiciary Committee that says, "Out to lunch, gone fishing." We were out to lunch because we're so far afield of what the American people want us to do. We've gone fishing because despite a 5-year fishing expedition which has yielded nothing more than allegations revolving around a tawdry sex scandal, this committee is still trying to bait the hook. What has disturbed me about the twists and turns of this investigation and these proceedings is that instead of seeking justice, too many are intent on winning the war. So when there's not enough evidence for impeachment, you bring in John Wang's name or Kathleen Willey to prop up the case. And I say to my Republican colleagues that the irony is that the harder you try to win the war, the more you lose the hearts and minds of the American people. Now, for Mr. Starr, the OIC has basically made 3 allegations against the president, 3 types of allegations: perjury, obstruction of justice, and abuse of power, all stemming from the president's admitted improper relationship with Monica Lewinsky. To me, as I have said and you have stated in your report, it's clear that the president lied when he testified before the grand jury. Not to cover a crime, but to cover embarrassing personal behavior. And as I have said before, the president's actions deserve to be punished, not as a political denouement, but because what the president has done is a serious matter that cannot go unanswered. However, It is clear to me that if this case, as it seems to be, and as it seems clear to me, is only about sex and lying about sex, that it will never be found impeachable by Congress, nor should it be. As I interpret the Constitution in the Federalist Papers, an interpretation that is diametrically opposed to yours, Mr. Starr, it's obvious that this does not reach the standard of high crimes and misdemeanors as set forth in the Constitution. The innate and sound wisdom of the American people that lying about an extramarital affair should not lead to the removal of a duly elected president from office is far more in keeping with the Founding Fathers' visions of impeachment than your legalistic arguments, Mr. Starr. So thus, it seems to me that if the charges of abuse of power and obstruction of justice lack compelling evidence, then the vast majority of Americans and a strong majority in this House will not vote for impeachment. So I'd like to ask you a few questions on the obstruction charges. I am not asking you about abuse of power because that has already been rejected as out of hand by even the president's harshest critics in the Republican Party. And I'm going to ask you 3 sets of short questions for you to answer together. And that will be the end of my questioning, so you'll have the rest of the time to answer. First, on August 20th, 1998, Ms. Lewinsky testified that, quote, "No one ever asked me to lie, and I was never promised a job for my silence," unquote. That was in response to a question by a grand juror. Let me ask you again, because I know Mr. Lowell asked this, but I didn't find the answer adequate. Why wasn't this statement directly included in your 455-page referral to Congress, not in a footnote and not paraphrased? Isn't that relevant, trenchantly relevant information about what we're doing? And if you are so dispassionate about simply producing the facts, why wouldn't you have included the statement verbatim and in quotes, particularly on a matter as important as impeachment? Second, regarding the Lewinsky job search, if the president and his staff began to find Monica Lewinsky a job sometime after December 5th, 1997, the date she first appeared on the witness list, that might lead one to your conclusion that there was an attempt to influence her testimony. But since the job search began more than 18 months prior, doesn't that cast into serious doubt an obstruction argument? You are assuming that once the White House knew of the deposition of Lewinsky, their reason for getting her a job totally changed, when it seems at least as logical that the reasons remain the same, mainly that they wanted to get her away from the White House for the obvious same reason that they did before they knew of any deposition. And again, shouldn't we set an impeachment bar high enough so that a 50-50 proposition like this does not set off a constitutional crisis? And third, and finally, on January the 18th, the president had the conversation with Betty Curry. Isn't it true that on that date, she was not listed as a deposition or a trial witness in the Jones case or any other case? For obstruction or subornation, the president would have to know that she was to be called as a witness. There's other logical reason that he didn't want Betty Curry to talk about this. He may not have wanted the press to know. He may not have wanted his family to know.
Can you wind up,
yes,
Mr.
this
Schumer?
is my last. And again, given the weighty matter of impeachment, shouldn't there be more evidence than just your surmise that the president knew that Curry would be called as a witness? Your answers, Mr. Starr.
Senator-elect and Congressman Schumer. Question 1. We did supply the information. The reason that you're having, of course, these questions with respect to the referral is because we produced everything that was relevant to your assessment of Ms. Lewinsky. And I stand by what we said in page 174 of the referral. I think it's fair in light of our assessment, but your assessment, of course, may very well be different with respect to that
But
one
I asked
item.
why you didn't put it in the report, in full, fully quoted.
Because we do not think that that is consistent with the truth, and it would be misleading to say, in our judgment, and I understand you may disagree with this, but we specifically said at page 174, not in a footnote, Ms. Lewinsky has stated that the president never explicitly told her to lie. If one finds that inadequate, then one finds it inadequate. It is your judgment, but we were holding nothing back. The referral contains the information. You have also the grand jury transcripts. I'll be very brief. With respect to the December 5, 1997 matter, and again, this is an assessment of facts. Our professional assessment of the facts included such significant things as a great stepping up of the efforts to get her a job, especially once the witness list issued, and the referral speaks to that in fairly elaborate detail, and how Mr. Jordan became very active in that effort. Again, it's our assessment of the facts.
There could be a reasonable assessment the other way, I presume.
Well, I've come to my assessment based upon my colleagues who are professional prosecutors' assessment of the facts.
It's beyond a reasonable doubt?
Oh, no, that's by no means is that our standard, because as you quite rightly note, the question is substantial and credible. And with respect to Betty Curry, I would simply guide the Congress again, the House again, to the substance of the President's testimony and how she was injected into the matter by the President in his testimony, and we think that does have significant...
All due respect, sir, that doesn't answer my question, which was not how she was injected or what the substance was. Please, Mr. Chairman, he didn't answer my question directly, but how did you come to realize that the President knew that she would be called as a witness when there was no mention of it at that time? Is this just surmise, or do you have any factual evidence that the President knew that she would be called as a witness? We understand he wanted her not to tell the truth, but we don't know to whom. Where's your evidence?
The evidence is not that she was on a witness list. You're quite right. She was not on a witness list, and we've never said that she was. What we did say is that the transcript of the President's January 17 deposition shows that he was injecting Betty Curry into the matter and saying, may I finish?
Sure.
And saying specifically, you will have to ask Betty. That raises...
It's nothing to do with the legal proceedings, sir, and that's the heart of subordination.
All right, the gentleman's time has finally expired. The gentleman from North Carolina, Mr. Coble.
Thank you, Mr. Chairman. Judge Starr, you have become the bullseye of the target upon which several aspiring political gunslingers have fired. A recent AP story quoted a Democrat member of this Congress saying the House Judiciary Committee Republicans are looking for a way to wiggle out of this mess. Let me get this straight. President Clinton was involved in an illicit sexual affair, strike that, illicit sexual affairs in the White House with a young White House intern of tender years. President Clinton subsequently assured all America that he did not have an improper relationship with that woman. President Clinton, continuing his denial, spoke untruthfully in a deposition or interrogatory and before a federal grand jury, causing perjury to rear its ugly head. And for all this, you are the bullseye of the target, and the House Republicans are trying to wiggle away out of the mess. I obviously missed class that day because as I review my material and notes, common sense and reality are conspicuously absent. Judge Starr, if one half of the unfavorable comments leveled at you are true, you probably should be keel-hauled. I'm inclined to dismiss most of them, and as evidenced by your demeanor today, I think most of that trashing was probably just that, trashing. Now, I'll admit I'm not happy with the cost of this investigation, but some of that must be attributed to the President's delaying and deceptive and evasive tactics. Let me go to page 21, Judge Starr. That's sort of what you were referring to earlier, where it says the facts suggest that the President was attempting to improperly coach Ms. Curry at a time when she was not a potential witness. Shouldn't the word "not" be deleted there?
Yes, thank you, Congressman. And in fact, I think the corrected version, which should have come up this morning, should make it clear that she was a potential witness.
And we now reached that she was a potential witness.
Yes, and I must say, because you've been kind enough to raise that, I would just say in response to issues about potential witnesses that federal law is clear that these prohibitions against importuning and coaching a witness do indeed go to a potential witness.
And I think the word "not" does appear in many of these of our scripts.
I apologize for that.
Judge Starr, what evidence did you find to support your conclusion that President Clinton's action involved public misconduct as opposed to private misconduct, A? And B, what evidence, if any, is there that President Clinton breached the public trust?
Well, Congressman, I'll be as brief as I can. In terms of the public nature of the conduct, it seemed to me, as I sought to set out both in the referral and this morning, that the key is this was no longer, and I respectfully disagree, but it's not my judgment that governs here. I respectfully disagree with the suggestion that this is, quote, lying about a private sexual relationship. Rather, this is the integrity of the judicial process. These are courts we're now talking about. These are judges, and a district judge is sitting and presiding, and that is, it seems to me, what made that dimension of it very public. But the other aspect, which we do enumerate in counts or grounds 10 and 11, which are before you, is that in a variety of ways, the president used the powers and influence of the presidency to carry out this continued effort to deny and to delay, including, I believe, and this goes back to an earlier comment, when one looks at the pattern of activity that we summarize in grounds 10 and 11, one will see a course of conduct that I believe does, in fact, go to your point, both of your points.
Chairman Hyde, it can be done in 5 minutes. My red light has not yet illuminated, and I yield back the balance of my time.
I thank the gentleman, the distinguished gentleman from Los Angeles, Mr. Berman.
Well, thank you, Mr. Chairman. I've read the referral, and I've listened to the testimony with one possible exception. Judge Starr has answered the 595C other matter issues that I had concerns about, and I'd like to reserve the balance of my time at this point.
I'm sorry.
I would like to reserve the balance of
You certainly may. Well, you say he can't, but I'm going to let him do it. Mr. He's a good man. We'll let him do it. But I have a short memory. The gentleman from Texas, Lamar Smith.
Thank you, Mr. Chairman. Thank you, Mr. Chairman. Judge Starr, your friends know you to be a dedicated husband and father and an individual of impeccable integrity. And on the professional level, you have served with distinction as a U.S. Circuit Court judge, as Solicitor General of the United States, and as an advisor to the Senate Ethics Committee. Those qualities of personal integrity and professional respectability haven't changed, but the rules of engagement have. As a practicing attorney, you are accustomed to legal procedures that put you on an equal footing with the other side. But as independent counsel, you were prohibited from commenting publicly on the details of the case, even as you were unfairly savaged on a daily basis. So I understand why you welcome the opportunity today to testify and to respond to our questions as you have done so well. Judge Starr, during your investigation, the President claimed executive privilege to withhold information from you and prevent witnesses from testifying. While his claims were ultimately overruled by the courts, they did cause long-term delays and, in fact, as you said, obstructed your investigation. Executive privilege only allows the President to protect national security secrets. It cannot be used to interfere with a criminal investigation. Since President Clinton and his lawyers knew the law, they also knew that their claims of executive privilege were not legal. President Clinton's claims were thrown out by the courts, but not before they delayed your investigation by many months and perhaps over a year. Meanwhile, the White House complained that your investigation was taking too long. In short, the President took executive privilege, which is supposed to safeguard our country's national security, and misused it to obstruct the investigation. As you said in your opening statement, this is arguably an abuse of power. Judge Starr, my first question is this. In your referral, you said that the President had a pattern of invoking and then withdrawing executive privilege to delay your investigation. Could you give us examples of this?
Yes. The President would, in fact, through his attorneys, invoke executive privilege with respect to one or more witnesses, and when we would take the issue to litigation, I will be very specific. The President invoked, or the witness I should say, but had to do it at the direction of the President, namely Nancy Hernreich. Nancy Hernreich does not carry on, and by her own admission, a policy role at the White House. She does have an important function at the White House. She manages the Oval Office operations. It's a very important function. But that is not the kind of function that the principle of executive privilege was meant to protect. When we then, shall I say, called the lawyers on that, then it was withdrawn. That has happened to us before. It happened to us in the Arkansas phase of the litigation as well. Moreover, as we point out, the President told the grand jury on August 17 that he had no interest in this save in, and I'm roughly paraphrasing here, having the matter litigated. So it was as if it was to preserve the presidency and presidential prerogative. The history, when one then analyzes the facts, does not support that conclusion.
Okay, thank you, Judge Starr. And another question. President Clinton told the American people several times that he supported the public release of the court documents he used to claim executive privilege. Is that accurate?
The answer is partially, I would want to review the facts because I want to be fair, but there was in fact not, shall I say, a ready willingness to allow, for example, public access to the executive privilege hearings and so forth. So I don't want to be condemnatory, but I would say that the President did not show a strong interest in having this released quickly.
Judge Starr, a few minutes ago, counsel for the committee read an excerpt from a book written by Leon Jaworski. Let me read some other words that Leon Jaworski wrote in a book called The Right and the Power, which was about his experience as a special prosecutor during the Nixon impeachment proceedings. Quote, "No government office, not even the highest office in the land, carries with it the right to ignore the law's command any more than the orders of a superior can be used by government officers to justify illegal behavior. There was evidence that the President conspired with others to violate 18 United States Code, page 1623, perjury, which included the President's direct and personal efforts to encourage and facilitate the giving of misleading and false testimony by aides. For the #1 law enforcement officer of the country, it was, in my opinion, as demeaning an act as could be imagined," end quote. Do you think that passage from Leon Jaworski's book has application to the case at hand?
I do. My own view is Colonel Jaworski, were he here, would say, it is your judgment, but these matters are serious and clearly deserve to be analyzed in terms of the importance to our system of truthfulness and taking the oath of office seriously and the oath of a witness seriously. And yes, I do think that that Mr. Jaworski, were he alive today, would say, if lying to the American people is grounds for impeachment, as he thought it was, I believe, he would say lying under oath is as well. But again, it's your judgment.
Okay, thank you, Judge Starr. Thank you, Mr. Chairman.
Time has expired. The gentleman from Virginia, Mr. Boucher.
Thank you very much, Mr. Chairman. Mr. Starr, while you were not a witness to the facts which are at the base of your investigation and also your September referral to the House, I note that for a number of years you served as the Solicitor General of the United States and in that capacity represented the United States government in a variety of cases before the U.S. Supreme Court. I know a number of those cases during that period involved constitutional issues. So, in my opinion, that experience well qualifies you to answer questions on some of the broad matters of constitutional dimension that it will now be the responsibility of this committee to consider. Since your referral was received by the House in September, there's been a great deal of discussion about the importance of the rule of law and about the importance of the principle that no individual, including the President of the United States, should be above the law. It's also been suggested by some that the rule of law is only observed and that principle only honored if it is found that the President has committed a criminal offense while in office. He must then be impeached and removed from office. But my readings on the Constitution suggest that impeachment was never intended to be a punishment for individual misconduct. Instead, it was intended to protect the country. It was designed to advance the public interest and to remove a chief executive whose conduct was so severe that it fundamentally impairs the functioning of his presidential office. Punishment for the individual can occur in the normal course and through the normal functioning of the criminal justice process. So I have three questions for you. I'll pose these, and then you'll have the balance of the time in which to provide your answer. First, Mr. Starr, do you believe that the President would be vulnerable to the criminal law process for whatever crimes, if any, he may have committed while in office after he leaves the office? Would he be subject to the criminal law process after he leaves the office, assuming that the statute of limitations for that particular conduct has not expired at the time that an indictment is brought? And in answering that question, I would refer you to the provisions of Article 1, Section 3 of the Constitution, which states as follows: judgment in cases of impeachment shall not extend further than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. And I would assume from that language that there would be no doubt that the President would be subjected to the normal criminal justice process once he leaves office, and I would appreciate your concurrence or if you choose difference with that conclusion. Secondly, am I correct in assuming that the federal criminal statute of limitations for the perjury and the other offenses that are stated in your September referral is 5 years, and therefore that the statute will not have expired by the time this President leaves office in the year 2001? And third, if you agree that the President could be subjected to the regular process of the criminal law upon his normal departure from office in 2001, just as any other person could be subjected to that process, would you not also agree that in subjecting the President to the criminal law process, the rule of law itself would be well served, and that would also well serve the principle that no person, including the President, is above the law? So there are three questions that I have for you. First, is a President subject to criminal prosecution when he leaves office for offenses committed while in the office? Secondly, would there be sufficient time within the statute of limitations for prosecution of the perjury and other offenses suggested in your referral of September after the President leaves office? And third, does not that process well serve as a complete assurance that the rule of law will be fully observed? Your answers, please.
As to question one, I agree with your reading. I think the plain language suggests exactly that the framers did intend for there to be separate proceedings. And I also agree with your comment, if I add this, that it was not intended to be a sanction in the sense of the criminal law serving the deterrent purposes and the like that the criminal law at its best is designed to serve. I also would answer yes to your second question in terms of my reading, I should say, of the statute of limitations. In terms of rule of law values, I certainly think that there is strength in the proposition that no person should be above the law. But I would also say that there is a fundamental fairness question in my mind, charged as I am as an independent counsel, with opining in any way that could be interpreted as sort of a call as to what the appropriate disposition would be of a particular matter. I know what my duty is. One may disagree with my reading of my duty, but it was to send you this. And then I think in terms of fundamental fairness to all the individuals involved, One simply has to assess that after this body has done its duty and reached its judgment. But it would be, I think, wrong to answer that it would be right to vindicate the rule of law for criminal charges to be returned. I think that before we, let me be, may I, Mr. Chairman?
Please, go ahead.
Before we ever seek an indictment, we engage not only, and I would hope any prosecutor's office would do that, a very careful assessment of the facts, the elements of the offense, and the like. We go through each of the elements. We look at the witnesses and the documentary evidence and the like. And then we have to satisfy, following Justice Department standards, is it more likely than not that a fair-minded jury would convict based on these facts with the witnesses, and we take the witnesses as we find them beyond a reasonable doubt. Those are judgment calls that I hope that you will excuse me in terms of fairness and not speaking so directly to in terms of your third question.
Gentleman's time has expired. The gentleman from California, Mr. Gallagly.
Thank you very much, Mr. Chairman. Judge Starr, this has been a long day, and we still have a long way to go before it's over. So I really appreciate your effort to address all of the concerns of this committee, and thank you for being here. I'd like to speak briefly to the credibility of some of the witnesses that you interviewed during this the course of the last several months. Several key witnesses provided important testimony under oath before the grand jury. In numerous instances, their version of events conflicted with the testimony of the President. I'd like to know your observation of the witnesses and, in evaluating the corroborating evidence, assess the truthfulness specifically of Monica Lewinsky, Betty Curry, and Vernon Jordan. If you could kind of give us a brief assessment of how you feel their credibility is.
It is with some reluctance that I answer this because of fundamental fairness concerns. But let me say this. With respect to Ms. Lewinsky, I think she desperately does not want to hurt the President. And at the same time, she has a very considerable memory, a recollection, a memory bank of relevant facts that is quite significant. With respect to Betty Curry,
would the witness withhold for a moment? Those questions are tough questions. I wonder if it isn't awkward for the witness to assess.
Perhaps if Judge Starr would prefer that I visit another area. Just as we speak, I was handed this pass out that apparently is being handed out in the hall by, there's actually no attribution, but I assume it's from our colleagues and friends on the other side of the aisle, and it references contradictory evidence as it relates to...
Would the gentleman yield? I don't have a copy of that, so I don't know that we've received it.
Okay, well, I will see that we get a copy of it. I'm not going to make...
I've never seen that document before.
I'll be happy to do that, but what I'm not going to ask specific questions relative to this document other than that there is something being handed out contradicting that the President made an attempt to hide evidence of the gifts that he may have presented to Ms. Lewinsky, and I will ask that this be made a record of the hearing. But briefly, Judge Starr, if we could revisit the Jones deposition, the President was asked whether he had ever given any gifts to Ms. Lewinsky. Does the evidence gathered indicate that the President gave false or misleading testimony when he answered, "I don't recall"? And I think that maybe would address this handout that we're receiving.
Yes, our assessment, and this was an assessment shared by the very experienced and career prosecutors, was that the events of December 28, 1997 must have been so clear and vivid in any reasonable person's recollection that the President would naturally have recalled that on January 17, 1998, less than 1 month later, given the nature of the events, which are undisputed, of what happened during that Oval Office visit by Ms. Lewinsky to the President over the holiday period. The recollection was so clear, or the events were so clear, that to suggest that one doesn't recall a Rockettes blanket and the like, the various gifts that were shared between the two, just, in our view, defied credulity, especially in light of the fact that we did have testimony, which is now before you, that the President was blessed with one of the most powerful memories that many people who have come in contact with a wide variety of people have ever seen. So we're told the President's memory is extremely strong.
But Judge Starr, would you say that it would be reasonable to say that might be selective recall?
Well, I don't like to get into characterization, but I would simply say I would not resist such a characterization.
Mr. Chairman, I appreciate the opportunity to participate and yield back the balance of my time, and I would like this to be made a record of the hearing.
There is some objection to that. Can we discuss that?
That's fine.
Thank you.
I would withdraw that request, Mr. Chairman.
Thank you. The gentleman's time has expired. The distinguished gentleman from New York, Mr. Nabler.
Thank you. Mr. Starr, we all agree on the paramount importance of the rule of law. Now, Section 594 of Title 28 of the U.S. Code requires an independent counsel to comply with the written or other established policies of the Department of Justice. Section 77.5 of Title 28 of the Code of Federal Regulations states in relevant part, and I quote, "An attorney for the government may not communicate or cause another to communicate with a represented party who the attorney for the government knows is represented by an attorney concerning the subject matter of the representation without the consent of the lawyer representing such party." Close quote. Now, I would point out that with respect to Monica Lewinsky, her attorney was Frank Carter, who is a criminal as well as a civil attorney, who ran the public defenders program in the District of Columbia's criminal courts for a number of years. And the subject matter of the representation, he was the one who developed the affidavit in the Paula Jones case, which was one of the subjects that you were going to question her about, which was the subject of the investigation. Now, these regulations are intended to ensure that a person's right to counsel is respected. Under this policy, your office never should have contacted Monica Lewinsky directly on January 16th without the consent of her attorney, Frank Carter. I have two questions. My first question, but I'll ask you to withhold till my second is asked, is why did your office violate the law and the Justice Department guidelines by contacting her directly on January 16th, since your answer to Mr. Lowell's question is obviously not correct, given what I just said about Mr. Carter's representation in the Jones affair and his being a criminal attorney. Second, under the Justice Department guidelines for all federal prosecutors, it is unethical to keep criminal suspects from calling their lawyers. The evidence suggests that Lewinsky was told by your office not to contact her counsel, and that your office, in fact, suggested that her immunity deal was contingent upon her not contacting him. Here are excerpts of Lewinsky's grand jury testimony. Lewinsky: I said I would like to talk to them without my lawyer. They told me that if my lawyer was there, they wouldn't give me as much information, and I couldn't help myself as much. So that, a juror: did they ever tell you that you could not call Mr. Carter? The witness: no. What they told me was that if I called Mr. Carter, I wouldn't necessarily still be offered an immunity agreement. A juror: sounds as though they were actively discouraging you from talking to the attorney, to an attorney. The witness: yes. A juror: is that a fair characterization? Yes. Independent counsel: well, from Frank Carter. The witness: from Frank Carter, who was my only attorney at that point. I didn't have another attorney, and this was my attorney for this case. So, a juror: and this is the attorney who had helped you with the affidavit? The witness: yes. And the affidavit wasn't even filed yet, unquote. The right to counsel was not a trivial issue here. Lewinsky points out in her grand jury testimony that when your office confronted her on January 16th, her affidavit had not yet been filed in court. It wasn't, in fact, filed until 4 days later on January 20th. Isn't it a fact, sir, that had you allowed Ms. Lewinsky to contact her attorney, Frank Carter, on January 16th, he could have withdrawn the affidavit or amended it prior to filing it in court, and in that way substantially weakened any criminal case against her? And isn't it a fact that the effect, and perhaps the real reason, for your office telling Ms. Lewinsky not to contact her counsel on January 16th was to prevent his withdrawing or amending it, was to prevent his withdrawing or amending her affidavit, and thereby substantially weakening the criminal case against her and subsequently against the president. In other words, isn't it likely that if you had not violated the law, one of the foundation stones of all the alleged crimes in the Monica Lewinsky affair would never have occurred?
Congressman,
That's my second question.
you did ask what I took to be several questions, but I have to disagree with the premise, and I disagree strongly with the premise.
Which premise?
We did not violate the law, and if I might explain why, and it has been litigated. If I could answer. These very issues, which you have very clearly stated, have been argued in a court of law. The chief judge of this district has addressed these issues with respect to whether there was a denial of counsel. Good lawyers can come up with good arguments. I don't know.
Can you tell us why this was not a denial of counsel?
She concluded, based upon all the facts, that Mr. Carter was not her counsel for purposes...
Excuse me, 11 hours later, after she was held for 11 hours, after your people told her that if she retained Mr. Carter, if she kept Mr. Carter, rather, that the immunity deal would not be on the table, after your people told her incorrectly that he was not a criminal attorney, after it was made very clear that she'd better not keep him, she then...
Mr. Nadler, you had a 5-minute question. When you let him answer?
Congressman, I disagree with all respect with virtually every premise that informed every...
Let me ask one-sentence question.
No, just a moment. Now, be fair. Let him answer your question. Will you?
Well,
You don't have time for another question.
Well, that's why I wanted to ask.
I know that's why I wanted to ask.
Well, if I can be very, very brief, but you stated a number of things, and with all respect, they were virtually all incorrect. And let me begin by saying, to the extent that your concerns are, and anyone should be concerned with respect to issue of denial of counsel, the issue has been litigated, as I was just about to say, and resolved adversely to Ms. Lewinsky. She had very active lawyers. They knew how to make arguments. That's where we argue these things in court. She lost for reasons that I tried to explain in terms of my colloquy with Mr. Lowell. But let me also say, because there's been a number, and you began, as I recall, your comments with DOJ policy. Congressman Nadler, the assurance that I want to give you is that we consulted with the Justice Department about the procedure that we were going to employ prior to the time that we engaged in the procedure, and the procedure that we engaged in is what law enforcement does all the time. And as I said this morning, it's not our job to reinvent the investigative wheel. We follow traditions and traditional practices, and that is what we did in this instance. The Justice Department knew what we were going to do, and they knew specifically about the Frank Carter issue.
They knew you were going to threaten her not to keep Frank Carter as your attorney?
I again disagree respectfully with the premise. I'll be very brief. What we put before Ms. Lewinsky was a choice. She had committed felonies. She was involved in the middle of committing additional felonies, and we said to you, you will be of assistance to us, have the potential assistance to us, if you become a complete cooperating witness. Now, you have the right, and as I said earlier today in a colloquy, we in fact placed a phone call to Mr. Carter that evening. We scrupulously and assiduously abided by right to counsel, but we also had reservations at the time about Mr. Carter. We don't have those reservations anymore. I want the record of this proceeding to be absolutely clear. Mr. Carter was an unwitting participant in drafting a perjurious affidavit. But, Congressman Nadler, we did not know that at the time. He had been engaged by Mr. Jordan, and we were looking into and telling the Justice Department, here are the issues that we want to look into. We want to see, is there something here that may involve criminality at a very high level? And we informed the Justice Department. We abided by Justice Department practice and policy. The issue was litigated, and the chief judge of this district has adjudicated the matter and has determined that there was no deprivation of the right to counsel. To me, it seems to me that matter should be viewed as as closed in terms of the legality of the process.
The gentleman from Florida, Mr. Kennedy.
Thank you, Mr. Chairman. Mr. Starr, I want to thank you for coming today. I appreciate your testimony. And as I have listened to the questions this afternoon, and as I've observed the response to your referral and the response to your investigation over the course of this year and actually prior to this year, I've been reminded of something a lawyer said about 2,000 years ago, giving advice to other lawyers. He said, and I paraphrase, if you don't have an argument, abuse the other side. Lawyers today, I think, are all familiar with advice that if the facts are against you, argue the law. If the law is against you, argue the facts. And if the law and the facts are against you, just argue like the devil. And I think what we're seeing
Would the gentleman yield?
I'd be
I think
happy
the
to.
punchline on that is beat up on the lawyer.
That's a variation on the same theme. And I think what we're seeing here is a desperate attempt to get away from the facts of the case against the president. Now, I understand that because I find that the facts are particularly compelling. I think your referral sets forth in great detail a pattern of calculated and sustained misconduct by the President of the United States. And I understand why the President's friends would instinctively react to defend him. But what is going on in attacking your investigation is not right. It is not consistent with respect for the rule of law. And I believe that the attacks that have been launched against you are without substance. They don't have merit. And even if we could accept for the purpose of argument that some of these attacks had some merit, it's obvious that they do not bear in any way on the reliability or the credibility of the facts of the case against the president. Now, if someone could show me evidence of misconduct that actually went to the credibility of the evidence, if they could show me that the evidence was not reliable because of misconduct, and they could prove the misconduct, I think that would be appropriate for us to consider. But we're not hearing that. What we're hearing here is just a grab bag, anything that occurs to try to undermine your credibility. And of course, this committee's process has been attacked in the same way. Anytime we come to the point of talking about the facts of the case with respect to the conduct of William Jefferson Clinton, some people cry unfair. I think it's fair to talk about his conduct. I think that's what we need to focus on. I think that's our responsibility. And it would be a dereliction of our responsibility if we allowed ourselves to be diverted from that fundamental task that has been given to us by the House of Representatives and the resolution that they adopted. So that I make by way of a general comment about what's going on. And I'm struck by the concern that has been expressed about due process. And I think we should all be concerned about due process. I think that's very important. But I must ask, where is the concern for due process in a person who lies under oath in a deposition? Where is the concern for due process in a person who withholds evidence and attempts to encourage others to withhold evidence? Where is the respect for due process in someone who coaches a potential witness? Where is the concern for due process in the whole course of conduct which you outlined in your referral with respect to the President of the United States? I see a stunning lack of respect for the due process of law in the conduct of the President of the United States as it is set forth in your referral, and for which we seem to have no rebuttal, no significant rebuttal offered. I want to know if there's going to be a rebuttal offered to these facts. So far, we're not hearing that. And so far, in the questions that are being directed to you, the focus is not on the facts of the case. Occasionally, they'll touch on that, but the focus is on other things diverted to designed to divert attention from the fact of this case. And I felt compelled to say that because this is a process that needs to be on track, and all of us need to focus on the critical questions here. Did the President of the United States lie under oath in his deposition? Did the President of the United States lie to the grand jury? Did the President of the United States obstruct justice? And did the President of the United States engage in an abuse of office in the way that you have outlined? Now, there's not time for you to respond to that, and that's not really meant as a question to you. It's meant as an observation on where this proceeding should be going and on the attempts that are being made to divert this proceeding from its proper goal.
Thank you, gentlemen. Time is up. The gentleman from Virginia, Mr. Scott.
Mr. Chairman, I have to first note that the witness today, Mr. Chairman, I first have to note that the witness today is the prosecutor in the case. Most prosecutors begin their presentations in court with an admonition that what they say and what defense counsel says is not evidence. Evidence will be heard from witnesses. As Mr. Conyers has said in his opening remarks, many of us have questions involving prosecutorial misconduct, illegal leaks, conflicts of interest, questions which are relevant to our oversight responsibility of the Justice Department and independent counsel, but irrelevant to the question of shall the President be impeached, which is the issue of today's hearing. And so I'd hope we don't discuss the unfairness and absurdity of basing an impeachment of the President of the United States on a presentation from the prosecutor and a review of written statements, many of which were not under oath, and which were subject to cross-examination. So the fairness of these proceedings continues to be an issue. Fairness was an issue when we didn't give the President an advanced copy of the report so his response could appear on the Internet along with the allegations. Fairness was an issue when we voted to begin the inquiry of impeachment before we'd had the hearing on what constitutes an impeachable offense. Fairness was an issue when we were denied the opportunity to take depositions so we could properly hearings. And you can see how difficult it is to get the use of 5 minutes. I don't know what the answers are. Fairness is an issue when the scope was expanded one night before the evidentiary hearing. So fairness has always been an issue. Mr. Chairman, I do want to thank you and Mr. Kennedy for finally convening a hearing in the background of impeachment, so at least we now have a framework in which to review the allegations before us. That hearing was necessary because we heard from 400 historians and received a letter from 400 constitutional authorities, another letter from 200 constitutional law professors which warned us that not one of the allegations constituted an impeachable offense. We heard discussion today about the rule of law. At the hearing, we heard that the Constitution restricts our legal authority to impeach the President to those offenses which constitute treason or other high crimes and misdemeanors. At the hearing, we dealt with issues such as the difference between impeachment of judges and impeachment of presidents. We addressed a question of when perjury can constitute an impeachable offense and when it should not constitute an impeachable offense. And we worked to evaluate a standard for impeachment considered whether commission of a crime which would violate the oath to faithfully execute the laws, whether that could be an appropriate. At our hearing, first panel of witnesses, including the majority of which were invited to the public, agreed that the phrase treason, bribery, or other misdemeanors does not cover all felonies, and that is that the Constitution does not give Congress the authority to remove a sitting president based on the standard that he committed a crime and therefore failed to faithfully execute the laws. Remember, as my colleague from Virginia said, that the president will be subject to criminal prosecution after he leaves office, but they all agree that we do not have the legal authority to remove the president based on Mr. Starr's suggestion that he failed to faithfully execute the laws. And so the rule of law restrains our impeachment authority of treason, bribery, or other high crimes and misdemeanors, and that Democrats and even many Republican witnesses raised constitutional authority to use any or all of the charges for presidential impeachment. Mr. Van Alstyne, a Republican witness, as low crimes and misdemeanors, and further said that the impeachment pursuit of Mr. Clinton may well not be particularly worthwhile. When I asked the entire second panel about the Starr referral count 11A, executive privilege, the consensus on the panel was that the executive privilege charge was not an impeachable offense. For example, Mr. Cooper, a Republican witness, said that I do not think that invoking executive privilege, even frivolously, and I believe it was frivolous in this circumstance, I believe that constitutes an impeachable offense. And so some said that none were impeachable offenses, but there was a clear consensus that at least some of the offenses are too flimsy to pursue. This sentiment was reflected in the Majority Council's presentation last month, which left out some of the allegations. Mr. Chairman's public suggestion that we should focus on 2 or 3 allegations, and several Republican members of this committee
Time has
have
expired.
about 30 additional seconds, Mr. Chairman.
30 seconds without objection.
Mr. Chairman. Several Republican members of this committee who have publicly raised questions about some allegations. Because of the confusion over which allegations are actually participate in fact-finding when some allegations may well be dropped even if they be true. That's why I joined Ranking Member Mr. Conyers in a letter in confusion and determine which, if true, might constitute an impeachable offense. Unfortunately, and now we have the situation in which we have an open-ended, never-ending committee and participating in the spectacle of having the prosecutor serve. Thank you, Mr. Chairman.
Are you awaiting an answer, or was that rhtorical? It was rhetorical?
It was rhetorical.
Do you have anything you need to respond to that?
I don't know. I think I understood Mr. Scott's.
Very good. It was an interesting lecture. The gentleman from South Carolina, Mr. Inglis, I wonder if you yield to me briefly.
Certainly, Mr. Chairman.
Yeah, I just want to. Virginia said, I don't characterize your office as an independent prosecutor. You're not a prosecutor, you're independent counsel. In fact, you have given the president a pass on Travelgate, on all sorts of Whitewater. And so, as far as I'm concerned, and counsel should do, find where people are guilty, find where they're not. Let the chips fall where they may. In judges, we impeach judges for perjury. We impeached Warren. I participated in that all the way through to the Senate court for perjury. We impeached Judge Nixon for perjury. Judges are different. They have a different standard. I direct you to the Constitution. It says the president, vice president, and all civil, that's judges, shall be removed from office on impeachment for and conviction of treason, bribery, or other high crimes and misdemeanors. I can tell you in the Judge Nixon case and in the Judge Claiborne case. Now, if perjury could get a federal judge off the bench and can survive with a corrupt judge here and there, how much more one man who is head of the executive department and all of that. So I just think that's I would like to make to the
Mr.
gentleman.
Chairman,
And I thank
would
Mr.
the gentleman
Inglis
yield for
for
30? I would ask
time.
unanimous consent that his time be restored after the 30 seconds.
You want, if the gentleman doesn't mind, we'll
And I
give-
would ask that his full time be restored so we have his full. Mr. Chairman, I think one of the questions that we dealt with was the circumstances underlying the behavior. For example, some of the allegations, some of the people that were convicted, the perjury was lying about bribes and other serious and grievous abuse of their official powers. So I think I'd like to continue the discussion, which I can't do in 30 seconds, but I think that was the reason we all of those underlying situations.
All right. I thank Mr. Inglis. Thank you.
Thank you, Mr. Chairman. Judge Starr, I have two things to thank you for and two things to ask you about. First of all, the two thank yous. Read and actually heard some of the things that various political do. It makes me wonder why anyone would be willing to accept an appointment like you've accepted. And really, tremendous service that you do to the country, and I certainly appreciate you have been willing to come out of a very successful law practice to spend time doing this. I mean, like you pointed out in your testimony, you do, and for people like you willing to serve our country in this way, it's a wonderful service, and we all should thank you. And I hope that somehow all of that is forgotten of all of these things that have been said about wanting to defend a president. But they needn't attack the prosecutor, the special independent counsel that's appointed here. And Mr. Kennedy was saying that undermines the process, seems to me. So first of all, thank you for your work.
Thank you.
Second of all, thank you for your very passionate defense of the rule of law in the last 3 paragraphs. I think it's just a very eloquent statement that I've studied for years to come in law schools, and because truly it is a great statement and a passionate statement, the importance of the. Now that gives rise to my questions. And there's some discussion about constitutes an impeachable offense in the context of the violation of the rule of law. And it seems to me the rule of law has 2 components. One is an adherence to due process, and the second, an adherence to the principle is something you expounded on in these last 3 paragraphs. There are some people who would say that perjury is not an impeachable offense. We heard a rather of that here a week or so ago, and the sophisticated view that perjury is not an impeachable offense. Let me ask you, I think we know we know who the president is. The question is, who are we? We know the president has admitted to lying. He admitted to lying under oath. If he were here, I think he would say that he has not technically committed the crime of perjury because it wasn't a material fact. Mr. Kennedy, I believe, elicited some responses. No, it was Mr. Gallup elicited some responses from you about the deposition testimony, the grand jury testimony. In your mind, were those facts that the president was testifying to the grand jury testimony, and are the met in the referral on the testimony in the grand jury situation?
Well, Congressman, I have been somewhat reluctant to go all the way to say, in light of the to say that all elements have been satisfied, but let me say that in my own judgment, although this is a jury question, materiality, the Supreme Court has held, is a jury question, but I certainly think a reasonable person could very reasonably conclude that the elements were in fact present in the grand jury testimony by virtue of, as we've tried to outline in the referral, the number of statements I believe were knowingly untrue that I think conclusion to reach. Again, our mission or our ability in submitting this referral was to say there is substantial and credible information that an impeachable offense may have been, and that of course is the state of the record as it comes to you, but yet a reasonable juror could come to that determination.
The rule of law and the issue of whether perjury is an impeachable offense, gather from testimony, and you would restate here, that in your mind, it is an impeachable offense.
Yes. Back to scholarly commentary and the like, that perjury is not only an impeachable offense as a and doctrine, and as a matter of common law. I think it's common law that it was viewed as a high crime or misdemeanor. But also, as the chairman has indicated, the very practice, so the common law of the United States suggests that it is in fact an impeachable offense, have been removed. The offense is the attack on the integrity of the judicial system. The response on the other side, well, we want to find out what the perjury is about. Some perjuries more seriously than others. And that is as a former judge, any judge worth his or her judicial salt will say, not in my court. Witnesses tell the truth. It doesn't matter what the underlying subject matter is. Once in court under oath, you tell the truth. That's the world, and perhaps that's why no judge being subject to impeachment or perjury has dared suggest, don't worry about an impeachable offense. It is. It's been viewed that way by
the gentleman from North Carolina,
Chairman.
Mr. Watt.
Mr. Chairman.
New York.
Mr. Chairman, I don't know if this is a point of order or a point of information. Indulgence of the chair. Mr. Chairman, a few moments ago, in response to my question, Mr. Starr referred to a case in Ray grand jury proceedings and the case which he characterized as the judge okaying the propriety of what they had done in the subject matter we discussed. Now, these cases are in the possession of the committee under, and I would like to be able to talk publicly about them, and I'd like to be able to whether the judge, Mr. Starr, correctly or incorrectly characterized this. I would like to know, since Mr. Starr has now referred to them, whether they're under seal, and if they are still under seal, I'd like to move them under seal.
I understand they're still under seal.
Can I ask the committee change that status?
Objection has been heard.
I didn't ask for unanimous consent. I asked for, I made a motion.
Well, I think it takes unanimous consent to take something out of from.
Mr. Chairman, I make a order that the motion is not in order.
Well, I has something to say. I want to hear it, but
well, it's very simple.
We'll talk later. It's really not your turn. You're not recognized for purposes of removing things.
Parliamentary inquiry?
Yes.
We are going to have a session later to vote on order for that motion then to be made at that time?
Yes, it would.
Very good. Thank
you. The gentleman from North Carolina will now against me the fact that Mr. Nadler intervened. I yield to the gentleman from North Carolina.
I want to re-inquire before.
Yes, sir.
Hey, chat. It is like, we're getting like every other word, and I'm not sure if I need to restart my computer or not, but it is bordering on the point where I don't even understand what they're saying almost. So I'm going to go ahead, split this into two different streams. If I can figure it out, hopefully it's like a restart thing. Maybe there's too much, my computer's been on too long, something like that. Usually that's what it is. So with that, I'll leave you to it. I'll probably be back. I might stream something tonight. I've been like getting into the habit of streaming before bed, and that's a lot of fun. Could be anything. But I have Oliver North testifying on the Iran-Contra scandal, CIA scandal, selling drugs in the United States to fund a war overseas, essentially. Well, I guess we'll all learn more about that together because I wasn't paying too much attention back then. But with that said, I'll leave you to it. I like to say, knowledge is power. Subscribe for more. I appreciate you guys joining me, having fun. It really is a blast with you. Chat's really funny. The bot is over zealous as it is. Let's say it's actually been doing pretty good at keeping out the spammers and stuff. So not bad. All right, everybody, take care. See you next time.